Please mention the date when it has expired. Yes.
But item number 120 is a disposed of matter, my lord.
Item number
120. But
120.
yes, my lord. It is a disposed of matter. This is the last order, my lord. Last, my lord. I haven't mentioned the matter, my lord. It is appearing in the list.
120 টা দেখে নিন তো, বলছে disposed of matter.
But I have handed over the order, my lord.
দেখে নিন।
আজকে লিস্টে আছে
all are analogous matter, my lord. The bank, my lord, sold the property to the promoter. I am the tenant.
What do you want?
Yesterday, my lord, the promoter, my lord, taking over position, my lord.
Yes, you have filed the motion.
Already 937, 938, 939.
937, 938, 939 of the monthly list.
Monthly list.
Please hand over the slip.
your lordship.
This it is appearing as 102. Yes, yes.
Urgency slip টা দিচ্ছি আমি।
Please wait. Let me see how far I can proceed. If not, please mention at the time of rising.
Lordship mention.
And you'll be allowed to mention the matter. It is listed under as 215 of this daily list under returnable motion. But I don't have any stay order in this matter. And already the
What do you want?
I just wanted stay order so that it can be updated.
The order, it is to be considered, sir.
Maybe update. The Calcutta.
Upgradation from the supplementary list.
The Calcutta University is the actual tenant.
All right, I will call your lordship. And the slip,
Matter, your lordship. It updated from there. I needed to mention one matter, your lordship.
division bench with
Contempt application, your lordship.
with whom? With justice?
The Justice Supratim Bhattacharya.
সুপ্রতিম ভট্টাচার্যের সঙ্গে জাস্টিস সুপ্রতিম ভট্টাচার্যের সঙ্গে ডিভিশন বেঞ্চ ম্যাটার যেদিন থাকবে সেদিন একসঙ্গে করবে দেখেন।
Item number 1. For expiry of 2019 suit bill.
Sir, I have asked you to hand over the slip. You did not mention. Please mention the urgency. Hand over the slip.
Item number.
The matter was taken.
May I have your lordship's kindly mention 6 matters when your lordship was appearing in these matters. But I was for requesting for your lordship's release this matter.
Yes.
I have mentioned the matter.
To be mentioned for non-prosecution.
May I have your lordship's time for release your lordships from the your lordship.
Sorry, for release, for release.
By that item number 134, Milord, this mention was allowed several times for upgradation. It is appearing item number 134. Trial court is fixed for judgment. The right evidence was closed. Defendant was not allowed to. This evidence was closed.
134.
134. This is the order of the trial court. Milord, kindly see this order. Kindly, Milord. The trial court recorded that revision is pending, but still, Milord, the judgment date is fixed for delivery of judgment. My lord,
134 টা নোট করে রাখুন 2 p.m.
my lord, I'm deeply respectful.
Is there any caveat?
No, my lord, this is not caveat.
Your lordship, item number 136. Today at 2 p.m. it has been fixed for argument. 25th is for judgment, your lordship.
136.
136, your
2
lordship.
p.m.
Grateful, your lordship.
Lordship, may to mention one matter.
Kindly, the matter was taken up on the 16th. The illness of the advocate and record, there was an adjournment that was sought for. Lordship had granted the order is the next. Lordship has adjourned it. Lordship has not made a returnable date. The difficulty
will come serially, yes.
Lordship, there's no returnable date. I'm only
It will come. Please wait.
hand up the slip.
You did not.
Lordships, kindly, may I permit to mention one matter. CO number 646 of 2025.
Why do you want?
My lord, it was appearing in the heading upgrade motion, and thereafter your lordship had a determination of the circuit bench, and thereafter again the matter got delisted. So for kind indulgence, we want urgent hearing, and it is that matter whereby the SAT has given a date on 30th
Please
of April.
hand over the slip mentioning the urgency.
Hearing.
Hand over the slip. Hand over the slip.
Under complaining circumstances.
All right. Everyone mention. Yes.
My lord, under complaining circumstances, I am mentioning one most urgent motion, my lord. For
Hand over the slip.
my lord, because my lord, police is harassing my lord. It will be
Please hand over the slip.
kindly accommodate my lord.
Hand over the slip. Hand over the
I
slip.
have mentioned the urgency the cloud to
Hand over the slip. Please. Please hand over the slip.
My lord, for upgradation, my lord.
Hand over the
My lord,
slip.
in the next date before the lower court is my lord, 26.
Mention that,
My lord, it's mentioned.
hand over the slip.
Grateful, my lord.
Lordship, for upgradation. Upgradation of monthly list item number 5.
Yes, yes.
Lordship,
Lordship.
permitted to mention under compelling circumstances, Lordship, both are, there are two matters, Lordship. Both are analogous matter and the date is fixed before the learned.
Madam, please hand over the slip.
Lordship, may I be permitted to mention one matter, Lordship, from daily list, item number 126, Lordship. This matter under heading upgraded motion, and this matter already heard by Lordship yesterday. And Lordship fixed today, that is 126 item number, Lordship, and yesterday date fixed, Lordship, in lower court.
Yes. 126.
Yes, Lordship.
That's mentioned.
126 2 p.m.
2 p.m. Grateful, Lordship.
My lord.
Lordship.
On Friday, Lordship, because the next day, learned court will.
Please hand over the slip mentioning the urgency, madam.
My lord, the item number 1693, my lord. My lord, item number. My lord,
Hand over the slip.
my lord, item number 169, my lord.
Your Lordship, I'm an octogenarian, I'm a widow, and this is regarding, LA case, which they took over my land, my husband's land.
Hand over the
So, you see that,
Hand over the slip.
yes,
My lord, yes. My lord, may I be permitted to mention that item number 169. The urgency is then, it is
Hand over the slip.
handed over the scene, my lord.
Why are you mentioning there if you have handed over
Urgency is then, my lord. The matter has been transferred from Barasat court to Alipur court, my lord. But the advocate of the Barasat court has not been cooperated with the petitioner, and they are demanding huge money from the petitioner.
that submission you will be making when the matter will be.
My lord, the admission has already been granted by the Lordship Justice Basu, my lord, and notice has already been served. But kindly fix it date.
Sir, you have handed over the slip. I will consider
I have
that.
handed over, my lord. Lordship, may I be permitted to
74. I'm coming from Kishanagar, appearing in person. The lower court is creating pressure to continue for
Hand over the slip. Hand over the,
stated 19.5. Please see the matter, please.
hand over the slip. Yes.
Lordship, may I be permitted to mention one extension of interim order, Lordship?
When it has expired,
It will expire on last week of April, Lordship.
hand over the slip.
Grateful, Lordship.
Lordship,
Extension of interim order.
Lordship, may be permitted to mention one application for upgradation, Lordship. It's a transfer
Yes.
application, Lordship.
Yes.
The problem is, Lordship, after filing of the revisional application, the lower court
Please
has
hand over the slip. Please hand over the slip. You have handed over the slip. All right. Yes.
extension of it.
Yes. Yes.
Grateful to
But the trial court, actually, the trial will commence on the 17th of April. So, we will be updating.
Yes. Yes.
But may I have your lordship's leave to mention, my lord, item number 131 of your lordship's daily list, my lord. I have already handed over the slip, my lord. This matter was taken up on 7th of March and 10th of March, my lord. It was
All
fixed
right.
on 18th.
Yes.
My lord, it is going down, my lord.
So the application of a matter of.
Please hand over the slip mentioning the urgency. Yes.
বলছে আলিপুর কোর্টে আমার 8 তারিখের ডেট আছে, তার আগে যদি না করেন
স্লিপটা দিয়ে দিন। Yes.
8 তারিখের আগে করবেন স্যার।
Yes. Hand over the slip.
Lordship, may I mentioning one matter in the monthly list, item number 1185, Lordship, the
Upgradation.
the matter is re-list called because the other side is appear. Many times you appear in the other side, Lordship, in the opposite party, Lordship.
I appeared.
Yes, Lordship. 1185, Lordship.
1185 to 2 mentioned for release.
Get upgradation.
Yes.
তারিখে
Yes. On the list.
Before your lordship calls the list,
mention of upgradation, my lord.
Please hand over the slip, madam. You did not mention.
My lord, it did not come up before your lordship.
Please see the endorsement in the mentioning slip.
May I permitted to mention, my lord?
Hand over the slip mentioning the urgency.
may I have, my lord, this is not a matter in your lordship's list, nor am I mentioning for upgradation. My lord, on 25th of March 2025, my lord was pleased to dispose of a civil revision application. It was this expediting, my lord, an application, expeditious hearing of order 37. Now, my lord, there was no caveat, so we were not there. Now, my lord, what had happened is, my lord, if your lordship sees your lordship's direction,
Yes. Yes.
my lord, kindly come to page 2.
Yes.
Milord, the third paragraph, considering the fact that 22nd April has been the fixed for IA2 of Sindhi, it is disposed of by requesting the learned commercial court to take up hearing of IA2 on the next date, that is on April 22nd.
Yes.
If hearing of is not concluded on the next date, it is to be requested. So, Milord, your lordship said dispose it of as expeditiously as possible. I have no problem with that. What happened, Milord, on 22nd, we were all there. This is the order.
You are not there.
We were all there.
Yes.
The plaintiff was not there.
But I was there, I.
Just a minute. I'm showing the
Yes.
order. No, no, it I think. Milord, your lordship will find, Milord, when the matter was called on, Milord, the plaintiff's advocate was not there.
Yes.
So, Milord, the court directed, accordingly, the plaintiff is directed to show cause why the case should not be dismissed, which is, Milord, the usual order.
Yes.
Now, after this was disposed of, Milord, kindly turn over the page. When we left, Milord, the plaintiff's advocate thereafter appeared. At the top, your lordship will find later.
Yes. Yes.
And he brings the order to the notice of the court. And, Milord, the court fixes today without any sort of hearing. Now, Milord, there are two things. Without any adjournment, he has fixed it today. And, Milord, they have not even communicated this order to me that this matter is fixed today.
But I think there was a direction.
No, the direction was to dispose it of on 22nd.
Yes.
They did not appear on 22nd when the matter was called on. The matter was adjourned.
But,
Just a minute, madam, I told you. Matter was adjourned till 2nd of May.
Yes.
And later they come and say, and Milord, the court
So it's fixed today.
fixed today. 20.
So
So,
takes-
only thing is this, Milord, there are two problems with it. One is, Milord, these clients, Milord, are in Bombay. They need counsels to come and argue this matter. I am not briefed in this matter, number one. Number two is this, Milord, what was not brought to your lordship's notice, that IA2 is an application for summary judgment. When, Milord, the plaintiff himself has not taken out any summons for summary judgment and has not been served on me when I have entered appearance as long back as in January of 2024. But these are merits.
Yes, those are on merits. You can take those
But
points.
all I am seeking, Milord, I am mentioning upon notice, Mr. Karmakar is here. Today, Milord, all of a sudden this matter has been fixed pursuant to your lordship's direction. He is here. So, Milord, if both of us can consent that we will go and take a suitable adjournment and let the matter be heard on 2nd, I have no problem.
Please make that, because this is a disposed of matter.
Milord, that's the reason I have served Mr. Karmakar, so if both of
Mr.
us can
Kormakar,
agree.
this order on that date when the matter was taken up, you were not present. They were present, and you were directed to show cause. By a later order, this order has been fixed.
Sir, I was
They were
not-
not notified. And also you did not communicate this order of 25th of March upon them.
Yes, from March they knew this order and they have not communicated to me that the matter is fixed. Yesterday, Milord,
They were.
they wanted to take me by surprise.
Mr. Kormakar, these orders are passed at times without serving. Then I will follow a procedure in all expeditious hearing matters. I will direct issuance of
My
notice.
matter was not for expeditious disposal. Lord, my matter before your lordship was not for expeditious disposal.
Yes.
Kindly recalls.
Yes.
My matter was, Lord, for passing a decree
Yes,
because they had not
for that
attended
I have
appearance
said,
within
for
time
that I have
and
said on the
contempt.
next date fix, it will be taken up.
My lord,
You should have communicated to them.
Lord,
this
they were
order.
present, even I was also present. I am told, my lord, till
You were
11.
not present, Mr.
I am
Kormakar.
told
When the matter was taken up, you were not present. You were asked to show cause.
11.
Subsequently, you appeared.
That's the problem with that court. I sit with that, not some authority, my lord, some responsibility. My lord, that's the problem with that court. My lord, when we go and submit, that court does not listen to anything.
Mr. Kormakar, that is a
And this is
different thing
unfortunate. This is
altogether.
an unfortunate thing that this has been recorded. The court said yesterday when my
Kormakar, this has been recorded. So if according to you, it's a wrong recording, you have to take steps
Yes,
accordingly.
yes.
So I cannot
Not
go into this.
Into all that, without getting into all that, what I'm on today, your lordship, is not next date has been fixed for show cause.
Today, 23rd of
No,
April.
later on, he fixed another that the matter would be heard today. In the fact,
Today,
on 20th, Rahul, in the fact that
23rd of April, today it has been
today at
fixed.
12:45, both parties are to come ready. And this order was passed at
We'll go there. Blood, let us face the blood on suit on merit.
Mr. Kormakar, please do something. I'm not passing any orders.
We'll go there.
Milord, I am only saying, Milord, since Mr. Gaurav, I have only been served with the order yesterday.
Please take that point, because now it's a disposed of matter.
I know that.
I cannot pass any orders
So, Milord, let
today.
it be understood as a fair answer
That
that
is
on
up to
2nd of
you.
May or any date.
I think you apprise the learned trial judge of these facts I think the learned trial judge will consider these facts.
Mr. Doctor has some problem today, my lord. I cannot stand, I will not stand.
So, Mr. Kormkar, he has problem for today. So do something.
The judge,
So
let
do
us take a
something.
judgment.
I'm not passing any orders. Please,
My lord, deeply obliged.
has to be because both sides are to be heard and an order is to be passed right this way or that way. It may go in
Yes,
your
very
favor
clear.
or it may go in
Absolutely,
Mr. Datta's
absolutely.
client's favor.
Should not come in the way, my lord. Mr. Datta is there, my lord. No,
Yes.
I was a little surprised when Mr. Kormkar was there and how this matter was handled, because I have a lot of confidence in
My
him.
lord, we have lots of mention.
Obliged.
I have already mentioned
I know.
application 16, my lord.
Contempt.
Contempt matter, my lord. You will actually call it.
Hand over the slip.
May I permit to mention, my lord, for upgradation, my lord, this is the
I
third
already
time, my lord, I have mentioned, my lord.
Have you seen the earlier endorsements in your mentioning slip? Please verify. Then mention.
May I permit to-
Please verify, then mention.
Yes, my lord.
What was the endorsement? Have you checked up? I've gone through each and every mentioning slip and I've made an endorsement. Please check up, then mention again. Yes. Please hand over the slip. Yes, call the list.
My lord, may I?
Yes.
May we permit to mention one matter, my lord? I've already mentioned this matter, my lord. Was pleased to allow the mentioning and directed the matter to appear under the heading adjourn motion, my lord. It did not appear, my lord. My lord, the urgency, my lord, is that this order of injunction.
Direction হবে না এটা adjourn motion এ নাকি direction ছিল তাহলে দিয়ে দেবেন. Yes, call the list.
One.
And for the petitioner, my lord,
Yes.
praying for non-prosecution. This is the letter, my lord. Petitioner and the matrimonial dispute between the petitioner and the husband opposite party is amicably settled outside of the court, my lord. And which
It has
was,
been submitted by the learned advocate for the petition.
She would recall, my lord, your lordship had passed a interim order till, my lord, 17th.
Where is the other side?
Lord, we had, my lord, served the notice, my lord, at the time of mentioning. Lord, what else, my lord?
But Mr. Kormkar, unless they are here, they have to be, please bring them. Otherwise, it will be a difficult thing because এটা কে নিয়েছিল? SS কে? তাহলে ওনাকে একটুখানি পে করতে হবে.
No, this is not something new that lordship is incorporating. Your lordship had passed this in.
Mr. Kormkar, I must see, and the other sides, where is your other side?
Lord, we have
Please.
given notice at the time of mentioning.
Please bring them because otherwise, who is the affected party?
The affected party will be.
ICICI Bank? No.
No, no,
The
other one.
please,
Lord,
please,
Somnath Bhattacharya.
please bring them because in their absence, it might be difficult thing.
Because in any event, my lord, we have filed already the appeal. The only observation that was required is, my lord,
Let me hear them because if they come and say something else, then it might be a
we were
difficult
heard
thing.
on the day your lordship had passed this order, my lord.
Let them come. I think they will also not dispute that.
Very.
So please bring them when?
Keeps it tomorrow in that case, my lord.
Tomorrow.
Tomorrow.
Or if you can bring them today also.
Acha, very
কটার
well.
সময়
I shall
করতে
try.
পারবো? SS কে খবর দিতে হবে তো একটু। Please bring your other side.
Yes, very, very.
হ্যাঁ হ্যাঁ সেটা একবার বলে দেন।
Obliged.
4 PM রেখে দিন। Please bring your not only service, please
Very.
make an attempt to bring them. Yes, call the next matter.
I'm the creditor, my lord, in this matter, my lord.
So this was the order was passed without serving
Yes,
KVA.
yes,
Without
If it was checked, Lordship, you were filing.
Why did you not serve them?
After direction, I served the copy, Lordship. After direction, I served.
Not after direction, it should have served prior to the direction. There was a caveat.
Lordship, yes.
I'm vacating the interim order, yes.
You were filing, Lordship, I checked the,
Yes, yes, there is an endorsement of caveat. You should have pointed out to the court.
department issued there is no caveat. Department issued the endorsement that there is
Yes,
no
my lord, where is that? There is a caveat. It has been endorsed.
Your Lordship, Mr. Bhattacharya is appearing. Your Lordship, Mr. Bhattacharya is appearing.
I appeared.
Mr. Shonak Bhattacharya is there.
Yes, since I'm not inclined to take up this matter on personal ground, this matter stands. Yes. You are for the opposite party. Yes. What is the stage of the appeal?
My lord, first thing, my lord, appeal preferred without any prayer for stay in order to avoid the occupational charge. My lord, what happened, my lord? My lord, miscase, my lord, under order 21 rule 97 allowed. Against that, one misappeal preferred before the court below and obtain stay on the day of delivery of possession with the help of police. My lord, court, my lord, granted stay for 15 days.
Thereafter, on the next day, my lord, kindly come to their conduct. They are saying we have no instruction to press the stay application, whatever your honor deem fit and proper, pass order. And on that day, my lord, it was dismissed on cost of rupees 15,000. No payment. Thereafter, my lord, again on the same ground, my lord, this CO was preferred before your lordships, my lord, just to avoid, my lord, payment. And my lord, very well they know the fate of the appeal, my lord.
Appeal has been heard.
Appeal heard 26/4, as per they are saying, my lord. I got it from their
28/4,
fixed for delivery of judgment.
What is the date of delivery of judgment?
28/4.
28/4, perhaps. Yes.
28/4.
Or
And what is the date fixed for delivery of possession?
Today, I have deposited, my lord, the 2 months back, my lord. My 50,000 will go, my lord. And my lord, what happened, my lord? They, my lord, apprehending, my lord, imminent eviction, they, my lord, damaging my collapsible gate of the premises, my lord.
Manoj, I don't have.
But kindly have a look. আরে আপনার মক্কেলকে জিজ্ঞেস করুন what they are
Manoj,
নিশ্চিত they are committed, my lord,
Manoj,
without
what
paying
date
rent,
has
my
been
lord,
done, that has
without
to be-
paying occupational charge. They took the risk.
Manoj, what date, Manoj, that has been done, that has to be
He
ascertained.
has right to pay for
Please
appeal.
ascertain, no
Manoj,
stay.
I had right to go for execution.
Yes, yes.
Manoj,
So,
Manoj, I have not
Has
done
the
that.
order passed in the miscellaneous appeal?
Manoj, I have
that is
annexed.
annexed.
I have annexed. And I have said,
Manoj,
to Manoj,
page,
as
my
this has
lord,
been preferred in
it-
Manoj,
yeah,
Order 21, Rule 97, I have mistakenly filed an appeal.
Yes,
When
yes.
I recognize that I have,
how,
Manoj,
my lord, decree will be
Manoj,
executed. It is of the decree holder.
Manoj,
It is of the judgment debtor to challenge the appeal, challenge the order in appeal.
Manoj, I beg pardon before the Manoj Chief Justice of the City Civil Court for filing this appeal. When
Show me that order wherein they have said that I do not have any instructions.
Yes, my lord.
Please show me that.
Page, my lord,
Manoj, page
81.
Page 81.
80, from page 18. Today is the date fixed for hearing of stay application filed in connection with misappeal on maintainability point. Learned counsel for the appellant appears and submit that he has no instruction to proceed with the hearing of the appeal from his client and left it to the court to pass necessary orders. Learned counsel for the respondent submitted that the appeal should be dismissed on the with cost as no appeal is maintainable against an order for police help. The appeal is misconceived and the appellant should be saddled with the cost of for delaying the process of the delivery of possession purposely only to harass the decree holder. Having heard the learned counsellor and appreciating the fact that no appeal lies from an order allowing police help simplicity by the executing court, the appeal is liable to be dismissed. That the miscase is dismissed with cost of 15,000 to be paid by the appellant to the respondent for the purpose is stalling the process of delivery of possession by filing frivolous case application before this court, knowing fully well that no appeal shall rise against the order. Simply the cost which has been informed by the respondent to have already been deposited, whether it is regarding police help cost. But this is the conduct before the appellate court. They have no instruction, but
Manoj,
self-same client, my lord, got my lord, pass instruction to his learned counsel to file this application before your lordships, my lord, to drag the proceeding
Manoj,
and deprive the decree holder to enjoy the fruits of the decree.
Manoj, this is misrepresenting, Manoj. Manoj, when I have noticed that, Manoj, I beg pardon, Manoj, that why I filed this appeal. Thereafter, Manoj,
Your client said, the advocate said no instructions. from the
Manoj, I
client.
have tried to, Manoj, that I have mistaken. I may have been permitted
Should have said that under mistaken. Why you have said that he has no instructions?
It has been
with the hearing of the
Manoj,
appeal?
it has been recorded like that, Manoj.
Please take steps that
Manoj,
it
which
was wrongly
take step?
recorded.
Manoj,
Please
Manoj,
take steps before that court was wrongly recorded.
Manoj, today is the date fixed, Manoj. That is why, Manoj, we
144 is there. 144 is there.
Manoj, kindly, Manoj. And Manoj, they are saying that, Manoj, but their application, they have.
Why you did not pray for stay of the execution when the appeal was pending?
Manoj, I have said that I have not, Manoj, delayed the appeal. The 2023,
That
the
cannot
appeal
be
is
a
filed.
ground.
Manoj, they are delaying the appeal. 2023, the appeal. Manoj, kindly, Manoj, I will pay, Manoj,
I'm appearing for the petition. This is a contempt application, Your Lordship. Lordship, since the month of January, rule was being issued, my lord. On one occasion, the alleged contemnor appeared, but the personal appearance was not dispensed with. Thereafter, Your Lordship was pleased to pass an order on 27th of March, directing the IC of Bashanti Police Station to ensure the personal presence of the alleged contemnor. My lord, no one has appeared today, my lord. I have served the copy, Your Lordship. This is my affidavit of service. The registry was also directed to serve a copy of the order, Your Lordship.
Yes, registry report taki. Seen the report of the Assistant Registrar 8. You cannot find the learned government pleader, then the senior standing counsel.
Lordship.
Inform any one of them. Ask them to come at 2 p.m. Yes, call the next matter.
8.
In this matter, I am for the petition. The direction has been made to the, whether any report has been submitted or not, I don't know.
You have communicated this
Yes,
order?
Yes.
Where
Communicated.
is the affidavit?
That is not with my client.
Please file the affidavit service. The learned advocate, the petitioner is directed to file the affidavit of service.
Nine.
My lord, I beg to appear on here.
Item number 9, I am appearing for the opposite party lordship, led by Mr. Ron Banerjee.
The interim order is
The matter is lordship very short. It can be subject to your lordship kind sanction. It can be disposed of also.
Yes, you are appealing for the
I am
opposite party.
appealing for the opposite party lordship.
Yes.
Lordship, this matter, the opposite party has filed a preemption case. The petitioner has challenged the maintainability of such case and
All right. I'm extending the.
I am led by
Yes,
Mr.
Mr. Banerjee.
They have taken the point that entire amount has to be deposited. That point has been taken.
Entire
Amount has not been deposited as per them. So the preemption case is not maintainable. They have taken this point. Petition was filed.
Parasatai Hospital.
Parasatai Hospital. But in this case, my lord, we have deposited the amount only vis-a-vis the share claimed by me, because one portion was not claimed by me at all, because it was already gifted to me previously. So I have only not paid the amount for the Millard.
Mr. Banerjee, can it be done in a preemption? What is the effect of an order of preemption?
The portion which is
your choice that you will be claiming a portion of that.
Because I am claiming that I am entitled to the entire land, but a portion is already not gifted to me previously. So that
Regarding that, there is no conveyance at all. That portion was previously conveyed to me, categorically stated. The rest of the land, which has been sought, preemption has been sought for
No,
that.
no, I could not follow. Um,
Suppose
which is the deed which,
yes,
in respect of which you are seeking preemption?
that appears at page 17 onwards.
Page 17.
Yes.
So, Mr. Banerjee, I am fixing a date. I am extending it till April. So, Mr. Banerjee, Law Senior Counsel appears for the opposition. The next matter.
I'm on behalf of the petitioner and led by Senior Advocate Gopal Chandra Ghosh. Kindly give a short pass over.
So, Mahato, you are opposing this extension of interim order. Interim order is still, it has already expired. Tomorrow,
Pass over. Give a short pass over.
what I do not know, Mr. Mahato may be in this. What long Passover is Passover? Passover করে রাখুন তারপর দেখা যাবে. Yes, next.
11 also same.
11,
give a
10, 11, same. Yes, call the next matter.
Continuing matter.
Yes.
12.
My lord, for your lordship convenience, I have made a short compilation. Like
Yes.
what the case about, what is the fact in issue, and also list update, which is
You are for the opposite party.
yes, madam.
Mr. Kormakar, you are for the
Fine.
petitioner. Yes, start. Yes.
My lord, the respondent number 1, 4, and 5, my lord, is the petitioner of your lordship.
Respondent numbers 1, 4, and 5.
Now, my lord, the complaint is with respect to medical negligence on account of death of the son of the my lord, opposite party number 1.
Sir, you can take your seat.
Yes, madam. I am comfortable.
Due to my lord, dengue.
Please take your seat. Yes.
Death on due to dengue.
Mr. Kormakar. Take a seat, otherwise, when you will be speaking, there will be no chair behind you. Yes.
Lord, the death on account of my lord, dengue. So, my lord, they had filed this application on 4th of July 2022.
The opposite party.
Opposite party. The complaint was lodged on 4th of July 2022 before the district commission. Thereafter, my lord, the matter was admitted on 5th of August 2022.
Have you prepared a list of dates? No.
The list of date, my lord, it's
I
there.
have prepared for your lordship's convenience, madam.
But it's there on the just the second page. It's there. In any event.
For you.
Oh, thank you.
Everything is there, my lord. My lord, just have a cursory look, and then my lord may ask him to.
Mr. Kormakar, you
Lord,
can also
before I
verify.
start, Lord, may I file the certified copy from the State Consumer Forums? Lord, on 4th of July 2022,
Displace na hoye jay kintu. Yes.
as I indicated, on 4th of July 2022, the complaint was filed.
4th of July.
July 2022, the complaint was filed. 5th of August,
Yes.
5th of August, 2022, the matter came up for admission.
Yes.
The matter was admitted and directions for service was issued. Now, the next date was fixed on 21st of September 2022. The date
Next date was fixed on 21st
of September.
That is by the order dated 5th of August 2022.
Yes. Lord, I shall take your lordship to that.
Yes, yes.
Just Lord, to give
Yes,
the
yes, with the dates. So
Yes.
21st of September was the date fixed for appearance.
For
And on that date,
on that
you
date,
appeared.
I appeared, I filed the wakalatnama, and I also paid for time to file the written version. Now, Lord, the court granted the time and fixed.
Consumer Protection Act আছে?
এই তো বললো যে আসছে।
Yes, 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 Mr. Kormakar.
So, on 21st of September 2022, the matter was next fixed, Lord, for filing written version on 10th of November 2022.
On 10th of
November 2022. Till this
10th of November 2022,
File.
fixed for filing of written version. Yes.
Now, till this, nobody had any objection. Nobody raised any objection. Neither Milord the complainant and Milord we.
This was wide order dated 21st of
21st
September.
September 2020. Now, Milord, I take your lordship to first the order dated 5th of August 2022 at page 93. Kindly comes to page 9.
Please complete this. Thereafter, I will come to the order.
On 10th of November 2022, I went there and filed the written version. As per the court's direction, I went there, filed the written version. Later, Milord, the opposite party number 2 and 3, Milord, 2 and 3 came and sought for further time to file written version. Thereafter, Milord, that was also permitted. My written version was accepted and their application to file, Milord, written version extending time, that was extended. Against that, Milord, the complainant went before the.
You are not the respondent number 2.
No.
You are not canvassing the case of respondent number 2.
I am 1, 4 and 5. Against that order, Lord, the complainant went before the State Commission. The State Commission said that the District Commission could not have, Lord, extended.
What is the date of that order?
Lord, that State Commission's order?
No. The District Forum's order.
District Commission,
extending
10th of November 2022.
10th of November.
10th of November.
Oh, it was fixed for filing. You filed and on that date itself it was extended.
Yes.
So this was challenged before the State Commission.
State Commission.
Yes.
The State Commission, my lord, with an order dated 5th of June 2024. 5th of June 2024, Lord, allowed their revision. Allowed their revision, thereby, Lord, reversing the entire order of 10th of November. Lord, also, Lord, taking out, Lord, my written version which was on board. And fixed the matter ex parte against us. Against that, Lord, we went up to, Lord, the National Commission. The National Commission affirmed, Lord, the State Commission's order. So, Lord, this is the entire gamut of the case. Now, Lord, kindly comes to page 93.
Yes.
Order number 2, your lordship would find. Today is fixed for admission hearing.
This is the order of the District Commission.
District Commission.
District Forum.
No, District Commission. Now it's Commission, no longer
Commission.
It's Commission.
Yes.
Lord, kindly seize, Lord, order number 2, order dated 5th of August 2022. Today is fixed for admission hearing.
Today is fixed for admission hearing. Peruse the complaint and the copy of the documents filed. Heard learned advocate, there appears material for admitting this complaint. Accordingly, complaint is admitted. Fixed 21st of September 2022 for SR appearance and for filing written version. Complainant is directed to take steps for serving notice such and such. Kindly turns over to page 95.
Yes.
This is the next day's order. Now, 21st of September 2022, order number 3. Learned advocate appearing for the complainant is present and filed.
Yes.
Blood. The complainant is liable to be sorry. Learned advocate.
May I take over a bit? No, the gamut of the entire matter is very small. I don't need to trouble your lordship with the entire thing. The problem is I am not at fault. My lord, on a particular date, I appeared and I said that I need to, my lord, file the written statement. The court granted me that time, and within that time, my lord, I filed the written version. I was not at fault in any manner whatsoever. Kindly turns directly, my lord, to page 93.
Yes.
My lord need not trouble my lord self with the entire. Kindly seize page 93 once.
Yes.
This is the day, my lord, which I entered appearance. Or rather, it was filed. The suit was filed. Turns over, my lord, to 95.
Yes.
And sees the date, my lord, order dated 21st September 2022. Learned advocate appearing for the complainant is present and files affidavit of service. However, opposite party number 2 enters appearance and undertakes to file written version on the next day. Opposite party numbers 1, 4, and 5 also enter appearance by filing separate vakalatnama and prays for time for filing written version. From the track report filed by the complainant, it appears that service of notice upon opposite party number 3 is still incomplete. So, complainant is to take afresh for service on opposite party number 3, fix 10/12/22 for filing written version by opposite party numbers 1, 2, 4, and 5, and for taking step by the complainant afresh for service of notice upon opposite party number 3. My lord, kindly marks 21st September, my lord, it was just before the Pujos. Kindly marks that and kindly keeps that in mind. And the next date was fixed, my lord, on 10th of November for, my lord, filing of my written version. This order remains unchallenged. Nobody, my lord, has challenged this order. So this order not being challenged, my lord, is on record, and I'm bound by this order, both of us. Whatever, my lord, the Supreme Court might say in an order, but this order, inter se parties, my lord, is binding. Then I file my written objection, written version, my lord, if your lordship sees at page 140. I'm not going into the merits.
Page
140. That's the day, my lord, it was affirmed. 9th of November 2022. 10th was the date fixed, my lord, for filing. I filed it, my lord, by 9th of November 2022.
Is there any dispute with regard to the filing of the
No,
written
there
version?
isn't.
The date of filing of the written version,
There is no dispute. So I filed it, my lord, before the day granted, my lord, by the court below. I filed it on that on a day before that.
This was affirmed, so
I filed it on the 10th.
Filed it on the 10th.
Turns over, page 141. 10th of November 2022. Today is fixed for taking steps up by the complainant afresh for service of notice upon opposite party number 3. The learned advocate for the complainant is present and files the postal track report. My lord, your lordship skips over. Learned advocate.
Page 141.
141, my lord. That's the order dated 10th of November.
Give me a minute. Yes.
My lord finds learned advocate for opposite party number 1, 4, and 5 files the written version. So on that date, very date, my lord, I have filed the written version. I have not prayed for any extension. I have not prayed for anything, my lord, that give me more time. I am going by the court's direction. The court has directed me to file it on that day, my lord, I have gone and filed it. They challenge this order. They challenge this order, my lord, of acceptance. This is challenge, my lord, kindly turns to page. The application, my lord, is in the next page, and the order, your lordship, will find, my lord. Order page, yes, the revision application, my lord, is order.
Mr. Chatterjee, give me a minute.
I'm sorry. Order page, State Commission.
State Commission, 177. 177. 177.
Yes.
Yes. Page.
Page, my lord, 177. Lord, before that, if I may, my lord.
What is 177? This is the order passed
Yes.
by the State Commission.
Yes. Kindly remembers 10th of November was the order, my lord, which was challenged. 9th, the previous order, my lord, was not challenged. Here, my lord, Justice Mondol, my lord, in his lordship's fairness, my lord, has been pleased to say that I cannot file a written version beyond 45 days relying upon a Supreme Court decision.
Where is that?
This, your lordship, will find paragraph 11 and 182. The reasonings are all before that.
Paragraph 11.
11. I am not troubling your lordship, my lord, with all the decisions which have been cited by the learned judge. Cease paragraph 11.
Is not within the jurisdiction.
Yes, sir.
So this is the finding.
That's the finding. And this is on, my lord, your lordship remembers, first day, time granted, not challenged. Second day, it was accepted. That order was challenged, and this says it's beyond its jurisdiction, my lord, to accept the written statement beyond 45 days. That 45 days was not fixed by me, or rather 50 days was not fixed by me. Kindly visualizes the problem why the learned judge did that. 21st September, my lord, the Pujo was just round the corner. So that 45 days takes us, my lord, within the Pujo holidays. And we've taken that in that.
The district commission closed during pujas.
My lord, if I'm not mistaken, it probably is, at least for some days. If I'm not mistaken. Nobody's case that it was, my lord, open or it was functioning and that I had to put in. Nothing, nobody's case. But I have taken this point, my lord. Kindly turns to my explanation to that, which your lordship will find at.
No, so after this, what happened?
After this, my lord, this went to the National Commission. National Commission says whatever the State Commission.
So again a revision from this.
Again a revision. Lies.
So this is the third revision.
Third revision. And then this third revision, my lord, comes up because of a direction by the Supreme Court.
Where is the order of the National Commission?
My lord, kindly first seize 208. I'll take your lordship.
208.
Yes. This revision is based on, my lord, the Supreme Court's direction.
No, please
First
show
National
me
Commission.
the National Commission.
Yes. Turns over to 209. And the
209.
Yes, but 209 should be a
No,
certified
209 is the, yes, after 209.
Yes, the certified copy.
Yes.
My lord, this is the order, and your lordship will see right at the end, the last page of the order. Internal page 9. Again, the reasoning, I'm not troubling your lordship. The decision of the District Commission to accept the written version of the petitioner's opposite parties after expiry of the stipulatory statutory period was a patent error of law and which has rightly been set aside by the State Commission.
Yes.
They all lose track of the fact, my lord, that I had not prayed for extension beyond time. I had not. If the learned judge at the first instance had told me file it within this period, I would have filed it within that period. The court said you file it within 10th November. I filed it on the 9th of November. And on the next date fixed. So I couldn't have done anything, my lord, beyond that. The learned, my lord, I cannot suffer, my lord, for an act of court. This is an act of court. But there's a huge thing, my lord, they love saying all that. Actors never grab a beat. I am not.
No one should suffer from
No one
the act
should
of
for the act of court. My learned senior friend yesterday said, my lord, it's contempt of court. No, it's not contempt.
No,
I
I'm
am
not saying anything on a lighter side. My lord, please mark this act of court.
Yeah, of course. Act of God and then act of court.
Cannot equate.
Yes, yes.
God and act of.
That's true. I agree with you. Now, but to us, the court is God. So now, my lord, what
Mr. Chatterjee, let us not go into
No,
that.
I'm not getting it. Now, what happens is that if the courts directed me to do something which is done in front of them, they do not challenge that. That you can't say that it's almost like playing like a googly. Very well, you let it happen, and I'm taken by surprise on that day when I am to file. I'm filing. I'm not paying for extension anyway. And I am being said that your written version cannot go in. And there are serious allegations here. It's not a very, there are points of law and there are points of facts here. A child of 19 years passed away. Very, very sad incident. I am not even, all my condolences to the family. I understand what they must have gone through. But again, the doctors are not God. Serious allegations are made, that you should have done this and you should have done that in consumer forum on the ground of medical negligence. I have my doubts how far that will go after the.
But I think the consumer forum, that for anything can be, if it falls within the services.
So it falls within a specialized provision, specialized act.
But that does not take away. Yes. You may be right that there are specialized agencies or forums created for deciding this type of allegations or complaints.
Yes,
but it does not take away the right of consumer forum.
I am not
under
saying,
this act.
I am not saying so at all. But there, whatever they will get out of the consumer forum has to be borne out by a specialized, if I may say, there is a specialized forum who will first adjudicate whether I was medically negligent.
That is on
and
merits.
thereafter.
That is on merits.
So that's why I say, if this goes unfettered, then there's a serious prejudice on me.
Section 3 of the act is very wide.
I bow down. But it goes unfettered. If my written version is not taken on record, as to say how I have dealt with the dengue which the child had been inflicted with.
For that, it is to be seen, Mr. Chatterjee, that whether this provision under the statute directing the written versions to be filed within a specified time, whether it's directory or mandatory.
No, that I cannot say.
That, in some cases,
no,
as in Section 34 of the Arbitration and Conciliation Act, it can be extended up to a certain limit, not beyond that. Not only 1 day beyond that.
Kamala, there is a provision 38(2)(a) which says 30 days, and then extension up to another 15 days, 45 days.
So, but the language is to be seen.
Not exceed.
Whether the
not exceed.
Not
exceed. I am on that.
So that is the outer limit.
That is the outer limit.
So it cannot be further extended.
Bow down to that. But I am not at fault for that.
That is a different thing altogether.
Completely. Because if the learned why it was taken into consideration? Because the puja vacations were there. And I have said that in my written version. Have a look at paragraph 9, 192.
So, but did you take this point?
I did.
For the National Commission?
I did.
Show me that.
Look to my show cause.
It's not the show cause, Mr. Chatterjee. Show me that you have raised this point at the time of arguments before the National Commission. You may have taken many points in your pleadings. You might have chosen to press some of those at the time of hearing.
No, that is something I don't know, but it's on record because I was not there before the National
Commission.
Because
Mr. Chatterjee, I cannot go beyond what has been recorded in the order.
Yes. Kindly have a look at my written version.
We have taken without seeing. I accept your contention that you may have taken many points in your application before the National Commission, but show me from the order that you have raised that point.
I can't, because it's a question of. Kindly have a look at 192 once.
192.
It starts off from 183. I'm sorry. It starts off from 187.
Yes.
Kindly turns to paragraph 8. 8. The Learned District Commission, in presence of the parties, suo motu fixed the next date for filing written version on 10th November 22 without any objection from the respondent number 1 and 2 complainants. Petitioners also never proposed or prayed for time after such a long period. Copy of the order dated Sansai Annex. During the period from 21st September 2022 to 10th November 2022, there was long state government holidays on account of Durga Puja, Kali Puja and Diwali. And
Is there
other-
any provision, Mr. Chatterjee, or have they used any opposition to this before the National Commission?
If I'm not mistaken, no. If I'm not subject to correction by my learned friend, I don't think so.
What?
Any objection to this petition before the National Commission?
Yes, my lord.
You have filed.
Yes, yes. The
Have a copy
original
of-
is on record, my lord. That original is still there, my lord.
So do you have a copy of that?
No, not
Are you
here.
carrying a copy of that?
No, no, no.
Mr. Chatterjee, they have filed a petition. Where is that?
Let them show me.
My lord, let my learned.
All right.
Oh, let them show. I have to deal with it because I am told they haven't.
All right.
On the official written version, she was there in before.
No, no, it's a document, sir. Kindly produce the
No,
document.
do you have a copy of, if you have,
Then
And we permitted to, so application was made, but when the written version was given, I
no,
waited.
not the written version, before the National Commission, they have filed this revision petition
Yes. Acha, before
So-
National Commission.
before the National Commission, not before the District
Okay, okay.
Commission.
Yeah, sorry, my lord.
Before the National Commission, they have filed this revision petition, which is starting from page 187, I think.
Yes.
So did you file any objection or
No,
opposition to
it
this?
was dismissed on the same admission day itself.
So no opposition
No,
to,
no, no, no.
all right,
Itself.
all right.
It was not
I wanted clarification to that extent only.
Yes, so grateful, my lord.
Yes, yes,
so there was no opposition to this.
yes.
Then, my lord, your lordship will find from the order paragraph 6.
Paragraph
6.
of the order.
Yes, sir. Your lordship wanted to see, my lord,
Yes.
and then paragraph 9. This is what it was pressed, my lord, before the National Commission. Specifically, paragraph 9.
Paragraph
been
9.
9. It has been.
No, this is paragraph 9 is the decision of the Constitution bench.
No, my lord, paragraph 9 is the.
Oh, sorry. I'm looking at, there are two paragraphs. One is quotation from that decision. Yes.
It has been argued on behalf of the petitioners, which your lordship wanted to know from me, my lord, that when the matter was taken up on 21st September before the district commission, it was specifically directed that on the next date, the opposite parties number such and such may file the respective written version. Thereafter, the petitioners, the opposite parties number 1, number 4 and 5 had duly filed the written versions as directed. According to the learned counsel of the petitioners cannot be penalized for complying with the directions of the district commission. The contention is that in the wake of the specific directions given by the district commission, the petitioner should not be faulted with for being guilty of any omission or failure to file the written version within the statutory period of 45 days. It has also been submitted that the order dated such and such whereby the next date was fixed and on which date the petitioners were required to or directed to file the written versions has attained finality and has not been up to challenge in any court or higher forum. It has been argued that the State Commission has not given due consideration to this conspicuous background, which has actually led to the omission of not filing the written version in time. Submission is that therefore the order passed by the State Commission should be set aside and the petitioner should be given the opportunity to file the written versions or else the defense may get seriously impaired. On the other hand.
Yes.
So now, my lord, your lordship will find, and then the decision, my lord, comes right at the end, paragraph 12.
Yes.
The matter appears to be quite simple and does not call for any
So according to you, though there is a time limit specified under the statute for filing of this written version, the district commission has fixed a specific time limit within which you have to file the written version, and you have complied with such direction and have filed the written version. So whether that written version can be taken off
the record.
Taken off the record.
So I am complying with the court's order. I am not praying for an extension on my own. On the particular day when the court wanted me to, my lord, file, that day, my lord, it has been filed. Well, I make a very subtle submission before your lordship, a very clear submission rather. My lord, a period is given, my lord, by the statute. The tribunal is also a court. It is inflicted, my lord, it has within it 151. without anything else. If the court has exercised, it's not for me. I have not asked, I have not prayed that give me time beyond 45. If the court has done it on its own without a prayer, my lord, from the litigant can't suffer for that.
Anything more, Mr. Chatterjee?
There's nothing really much more beyond that, but on this, there is one decision, my lord. Have a look at on that, my lord, massive 2004 volume 2 SCC 783 Act of Court.
2004 volume
2 SCC 783.
782.
83.
Yes.
Actus curiae neminem gravabit. Judge Sahib ke din. Have a look at paragraph 10. Lord, I'm not multiplying on it. There can be thousands, my lord, given to your lordship on this. This, I'll give it to you. This court dealt with the effect on the rights of the parties.
Mr. Chatterjee, do you have an extra copy, please?
I shall.
No,
Definitely.
I'm okay. I'm just reading.
Definitely.
Yes.
This court dealt with the effect on the rights of the parties who have acted bona fide, protected by interim orders of the court, and incurred rights and obligations while the interim orders stood vacated or reversed at the end. The court referred to the doctrine of actors and held that the doctrine was not confined in its application only to such acts of the court which were erroneous. The doctrine is applicable to all such acts as to which it can be held that the court would not have so acted, but if it had been correctly appraised of the facts and the law. It is this line was very important. It is the principle of restitution which is attracted when, on account of an act of the party persuading the court to pass an order, which at the end is held as non-sustainable, has resulted in one party gaining advantage which it would not have otherwise earned, or the party has suffered an impoverishment which it would not have suffered but for the order of the court and the act of such party, then the successful party finally held entitled to a relief accessible in terms of money at the end of the litigation is entitled to be compensated in the same manner in which the parties would have been in the interim order of the court would not have been passed. So, my lord, if the court had said that you have to file it within that period, I would have had to. And then if I had, my lord, gone and prayed for an extension, the court would not have.
According to you, or in other words, according to you, is that the stage for saying that whether there will be an extension, further extension, does not apply in the case on hand?
Doesn't apply at all.
That is sum and substance of
Sum
your
and substance, because I have not prayed. The court directed me, and I acted in terms of the court.
So it's not a case of extension of
It is
time.
not a case of extension. I'm so grateful to Lordship. That is exactly what my point is.
September 21st was
সেটা অনেকবার বলেছি, আবার বলবো? Because the first order was not under challenge. The order by which I was given, my lord, the permission to file, my lord, within that period of time was never under challenge.
Yes, that is the order dated 10th of November.
No, the order before that, 21st September.
Sorry, 21st of September.
Never challenged.
By which 10th of November was fixed for filing of the written version.
File it on that day.
Anything more, Mr. Chatterjee?
Judges are bound to make mistakes. Under pressure.
My learned friend is really, I mean, anyway.
You are reminding the court of those
Yes, my lord.
propositions. That we
Yes,
make
yes,
mistakes.
My lord, the first judgment came way back in 64.
Strategy, if you want to cite, you can cite that.
No, I don't want to, my lord. I just reminded your lordship that my lord knows it better than me. First judgment came in 64. The court
Strategy,
has
if you
a
want,
court
please
has a
cite that.
right to pass a wrong order. And that is why the provision of appeals are incorporated in the my lord,
On a lighter note, my lord, I hope my learned friend wants to say that he also has a right to say wrong submission.
That's the lawyer's prerogative.
A misleading submission.
But the problem is
Strategy,
you can't judge.
cite petition, you can cite that.
No, that's not something that I really want. The problem is you have not attained that right to judge whether I'm wrong or right.
No, definitely.
You don't have that.
That is my lord to judge.
Yes, yes.
I am also in equilibrium with you.
Yes.
May I, on behalf of the respondent number 1 and 2, the original complainant in the medical negligence case, the parents of the son who died. My lord, I have my synopsis before your good self.
Yes. Yes.
My lord has that?
Yes, yes.
Yes.
My lord, as I said, my lord, the case is about the medical negligence. Death has occurred and we have instituted an appropriate consumer complaint, which is CC 387, now pending before District Commission at Kolkata 3. And what is the fact in issue, my lord, why we are here before your lordship? Is the District Commission passed two orders, 1, 10, 11, 22, allowing the petitioners, that is original opposite party number 1, 4 and 5, to file their written version and take it on record. Since the District Commission has taken on the record their written version beyond 45 days, so we challenge before the State Commission in revision, my lord. The revision number is RP 152 of 22.
Yes.
Another revision was also filed, OP2, one of the doctor who is clandestine.
We are not concerned with
No, we are
that.
not concerned at all. So I am not harping anything on it. Please.
Yes.
And then, my lord, next point, my lord. Next point, my lord. The most important, my lord. Kindly see my list of dates, my lord.
Yes.
The second, third page, my lord. Which
Yes.
my learned friend, I don't know, he is not here. So, none of them has given any submission on the date of service. Pilot should take the date of service as a penultimate point when the service, the written version right is accruing on them on 45 days. Pilot, second, in my tabular presentation, 6/9/2022, notices were served on all the OPs, pilot. Here we are concerned about the petitioner. So 6/9/22, my lord, please mark this. And then, my lord, the order, the next date fixed was 21st September 2022, wherein the petitioners were permitted to file the written version. My learned friend has several times pointed out that we have not challenged the 21st September 2022. Kindly see 6/9/2022 and until 21st is 15 days. Why I should challenge? No wonder the Honorable District Commission give them any permission. As long as they are within the 45 days situation, why I should challenge? There's no point, my lord. So as per section 30, I am coming to that section also. So anyway, so point of my submission, respectful submission is that on 21st/9/2022, there is no point of the right that arising in my favor, the complainant's favor, to challenge. Because it is within 45 days.
Yes.
My lord, kindly mark the 6/9/2022 service on all the OPs, that is including these petitioners. From that, my lord, come to next column, my lord. Next tabular column, my lord. 30 days expire on 6/10/2022 from the date of service.
Yes.
And then, my lord, 45 days expires on 21st/10/2022. My lord,
Yes.
marking that?
Yes.
I'm so grateful, my lord. My lord, then their appearance was on 6/11/2022. Sorry,
No,
10/11.
they appeared on
10/11.
10/11 they have
10/11.
appeared. Yes.
So, my lord, see my next column, my lord. So, admittedly, 45 days statutory time limits for the OP from the date of first appearance, 21st/9/2022, expired on 6/11. Even if, my lord, kindly hear.
Yes.
My lord, kindly appreciate this. There are two kinds of limitation. One, statutory time limit as per section 38, which I will come back little later, is 45 days. 45 days as per the date of service 6/10/2022 expired on 6/10/2022. And even if we consider for a moment, there is no law, but there is only law that within 45 days, even from the date of their appearance, first appearance. So first appearance happens when 21st/2022. 45 days expired on 6th of November. They are coming up on the 10th of November. How can they? Even if I object, I don't object, that is immaterial for the time being. But please mark that. Even if from the date of first appearance, 45 days expired on 6th of November. And the impugned order by the let me mark. Yes, on case law.
Yes.
Mark this.
Yes.
Then we challenge that 10/11/2022 order, taking on record their written version, petitioner's written version beyond 45 days. And rest is the 5/6/2024, the State Commission has directed their written version to be taken off record, and they have been held ex parte. They took it to the Honorable National Commission. Honorable National Commission on the date of the admission stage itself heard both the sides. My learned friend was there, and after that reserved the things and then passed the order on 19/7, I think, 19 September 2024. Well, I'm going as per now my list of dates. It has importance matter.
Yes.
Relevance matter. And then Malad would see page number 4. Then they take it to the Honorable Supreme Court.
Yes.
I was there on VC because I was traveling then. What happened in the court, Malad, which is not recorded, says we cannot make a mention, Malad. So in Supreme Court, they asked for liberty to withdraw it. But can you see the Supreme Court order?
Yes, page 208.
Yes, Malad, 208. I think my learned. Yes, my lord. The 209, my lord.
Yes.
Special leave petition is dismissed with liberty as aforesaid. No problem, my lord. It is not simply stated that they are withdrawing it on the face of it. No. Since the universal SOMPO was there, they took a point that, my lord, universal SOMPO is there. I think we should go to the High Court. And naturally, the apex court has granted them liberty, but without dismissal of the SLP. Fair enough, my lord. Kindly see, my lord, list of dates again, my lord. How they are delaying and dragging the matter. This is another aspect, my lord. So 45 days and all those things is one kind of delay, my lord, delay and dragging. My lord, kindly see page number 3.
Yes.
My lord has the tabular presentation.
Yes.
State last but one presentation. My lord, 5/6/2024 was the order passed by the Honorable State Commission, allowing my revisions. And they filed in the National Commission the revision petition 1981 of 24 after more than a month. Then please turn over to page number 4.
Yes.
They filed SLP, which is a statutory SLP. According to them, 90 days was the statutory period as per the Supreme Court rules. They filed it on 89th day. All along, the matter came up before District Commission several times. They took only and only stand that we are going to High Court, we are going to Higher Court, we are going to National Commission, this, that. By what? 90 days delay? I mean, after 90 days, after 1 month, and again after 1 month. Now I kindly see this CO that has been filed. Last presentation, my lord, of the page 4, my lord, table of presentation.
Yes.
The Honorable Supreme Court has filed the I'm so sorry. Passed the order on 7/3/2025. When they have filed here, that is on 16/4/2025. Can they explain why 1 month? Why not 1 day? If they are so serious about that their right has been jeopardized by way of act of court, then commit next day itself. And an ordinary prudent person, I would have advised the person to go there, follow the next date proceeding. Why in 89 days in the Supreme Court and taking another stand before the district commission, knowing fully well the district commission will not have anything to say that, oh, we have gone higher court, so we cannot help it. Similarly, here also, my lord, why more than 30 days they took the CEO, filing of CEO? That is one aspect, my lord. And my lord, most importantly, which is of course is a matter of the Supreme Court's proceedings, this universal SOMPO, this judgment was passed on 26 July 2023. Kindly mark it, my lord.
Yes.
I have already noted, my lord, for your lordship's convenience, my lord.
Yes.
Para 4, page 4.
Yes, yes, I've seen that.
So 26/7/2023, a hospital called Peerless knows very well the provision of law and act of law also. If they are very conscious about the act of God and act of code, they should also be conscious about the act itself, act of the law itself. If they had the knowledge of 26 July 2023, it's a public record, public knowledge, why they have filed the SLP at all? And even if they have filed the SLP, taking the parallel stand in doubt in the district commission, saying that we have gone to Supreme Court, we have gone to National Commission. So this is the instance of delaying and dragging the matter of a medical negligence case, my lord. And the poor parents are being dragged, this court, that court, all three courts they have been dragged to. Kindly see, my lord, the provision of law. My lord, section 38. Although in my compilation I have given the things, my lord. But anyway, since the Bear Act is before your lordship, in my compilation, page 2, it is there, my lord. Because
Section 28.
Yes, my lord. Section 38.
38.
38, my lord.
Yes.
The heading is Procedure on Admission of Complaint.
Yes.
And then subclause 3, my lord. And then come down to subclause A of that.
Subclause
A. That is 33(3)(a).
33(3)(a).
Very important, my lord.
Yes.
May I read the A part, my lord? That will suffice everything. Then, and then 3(a) I will read, my lord. District Commission shall, if the complaint admitted by its under the subsection 2 of 36 relates to goods, in respect of which procedures specified in subsection 2 cannot be followed, or if the complaint relates to any services, then A comes, my lord. Refer a copy of such complaint to the opposite party, directing him to give his version of the case within a period of 30 days or such extended period not exceeding 15 days as may be granted by the district commission. It could not have been extended at all, even if there is an application beyond 45 days. Could not have been. Anyway, my lord, consider me, I have zero knowledge of everything, my lord. Come back to the hilly multipurpose, my lord. My lord, this is for your lordship's convenience. You have or shall I give? I have. Okay. My lord, hilly multipurpose cold storage case is very well known, my lord. Landmark judgment, not because that 5 judges, of course, it is a 5 judges constitutional bench judgment, my lord, on reference. (38)(3)(a), my lord. Hilly multipurpose.
Yes.
One of the co-judge was Justice Indira Banerjee in the bench, my lord.
Yes.
My lord, kindly see the last one, the operating part, my lord.
Paragraph
41. Last but one page, my lord, page number 46.
Please show me the issues first.
Yes, my lord.
Issues which were referred to.
Yes, so that's why let's come back to my compilation, my lord.
No, issues in the judgment. Please show me the issues in the
paragraph 3, my lord. The reference, my lord.
Paragraph 3, yes.
Yes, my lord.
Please, paragraph 8, my lord.
That's the first reference.
Paragraph 8.
Yes. That is on 447, my lord.
Yes, yes. 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 So two issues. One is whether the consumer forum has the power to extend beyond 45 days. And other is what should be the starting point of limitation.
Yes, my lord. That's the two things.
These are the
Answer
two
is,
issues which were answered by the
answer is 41, my lord.
41,
Page
yes.
41, 463.
Yes.
And the citation is, my lord, 2020 5 SCR 429.
2020 citation.
2020,
2020.
Sorry, I'm so sorry. 2020 5 SCR 429.
429.
Yes,
Yes.
my lord. The
Oh,
answer,
yes, it's
answer is
here within black, so it's not.
no, no. Actually, it's original from a website we have.
Yes,
taken.
yes, yes. No.
Because on
This citation was there. I was
yes,
thinking the citation is not there, but it's within that
Exactly.
black.
exactly.
Yes.
Well, both the answers is at page number 463, para 41.
Yes.
To conclude, may I read, my lord?
Yes, yes, I've seen that.
So district commission has zero power to extend even a day beyond 45 days. And that is all. Here this has happened. Now, my lord, they have taken a particular stand of not of this act of court and all that. Court is supreme, my lord. We are just a disciple of the temple, my lord. Kindly see. 5 judges, constitution bench judgment, which explains what the section 38(3)(a) is. Can we go beyond this? Answer is no. And come back to my original submission. Well, kindly see my submission, this presentation again.
Yes.
Third page, my lord. Third page, my lord.
Yes.
Date of service is 6/9/2022. And that expires on 21st/10/2022.
According to you, in view of the constitution bench decision, it should be from 6th of September 2020.
Follow is, my lord, as per as the answer given to the reference
Yes, yes.
by the 5 judges bench.
Yes.
Right? One more thing. We all enjoy puja like my good dear friend, my lord. But this puja and all that, if I understand a little bit of the law and procedures, my lord, so can that be, even if there is state holidays, my lord, unless by resolution or the circular or notification, this day should be excluded, is there, can that be taken into consideration also? No. This puja things, my lord, it did not come up before any commission. They may have read anything, but they may have submitted in the form of pleading. That's fine. I was there in the state commission. I was there at the national commission. I was there before the Supreme Court.
According to you, they might have taken that point in the pleading,
yes,
but not raised that point before the National Commission. I
even
think
if they have
that is
raised,
your-
my lord, can we go, my lord, as a citizen of this country under 141, my lord, to violate the constitution bench judgment? Answer is no. My lord knows everything on that, my lord. We are only, I mean, I think my learned friend's client has got lot of liberty to go here and there, my lord, at the cost of the poor complainant, my lord. Consider their plight, my lord. Court is being dragged for, I mean, the proceedings is being dragged since November 22, 10th November 22. We had to file the state revision before state. They filed National Commission, again Supreme Court, again we are here. Proceeding has not troubled a single inch, my lord. 2.5 years is gone. Nothing substantive had happened. And she is in the court also, the mother. Kindly see my conclusion, madam. Page 4. Everywhere they have delayed all the petition. Why they took more than 30 days to come here? It is their seat. As far as business is concerned.
Yes.
Why 30 days more? Conclusion, my lord. My lord, at the cost of my lord's time, I have to read out, my lord. The petitioner's OPs have, my lord, has that?
Yes,
Page 4?
yes.
Yep. Has been consistently dragging the matter from one court to another, that by these petitioners' OPs have delayed the
Yes, I've seen
complaint.
that conclusions are merely what you have submitted. They had tried to delay this. And one thing is with regard to the constitutional bench decision. These are your conclusions.
And most importantly means service was on 6/9/22. 45 days expired, they did not file. They first appeared on 21st of September. Even 45 days expired on 6th of November. They then again appeared on 10th November and they have filed on that day beyond 45 days, even if consider there is no law, my lord. Right, my lord? So we have to bind them, my lord. It is not there.
Anything more?
Practice of things, my lord.
Anything more? Yes, Mr. Chatterjee, anything in reply?
The first thing, Lord, the Constitution bench talks about an extension. Whether the consumer forum or the district forum has the right to extend beyond 45 days.
Yes.
There's no question of extension here at all.
In your case, there is no
There's
question of extension.
at all. So
No,
Constitution
there are
bench
two
doesn't-
things. Your case is simple. According to you, you have taken steps pursuant to an order passed by the district commission.
Have a look at.
So you could not have been faulted for having taken steps pursuant to an order passed by a constituted forum. And according to them, it's that it was your duty to file written version within 45 days from the date of.
Has said file the written version on 10th of November.
Yes, yes. That
Not
is your
even within.
submission. You are relying
That's
on
the order.
Yes, that's the order. So according to you, since the forum has or the commission now, commission has directed you or has given you liberty to file.
Has ordered, not even a liberty, has ordered.
Yes, has directed you.
Directed.
To file within a certain time and having complied with that direction.
I cannot be faulted.
You could not have been faulted. And according to them,
And about that
initial order could not have been beyond 45 days from the date of service of.
He has accepted that order. Secondly, my lord, he accuses me of dragging, which is completely wrong. Because they filed the revision application, my lord, before the state commission. After that, my lord, I have a right in law to go, my lord, to the National Commission. I went there. Thereafter, I went to the Supreme Court. Supreme Court said you go back to the jurisdictional High Court. So today, my lord, I am before your lordship because
his grievance is that during the why did you take 89 days? You could have approached the Supreme Court.
The law
much
gives me
earlier.
a time.
Yes, yes.
Law
He
gives
said
me
90 days time is there, but you could have, if you were so anxious in getting justice for your client, you could have approached. He's not saying that.
It's very weird to answer that. Then I should have filed it the next second. The order is passed and go and file the next second. That can't happen.
According to you, you should have,
Reasonableness.
law should have been much more prompt.
The reasonableness is given by the law itself. We presume that the law has not given a reasonable time. And if I'm within that time, it's under the law I'm doing. I'm not doing anything beyond law. So that accusation probably is not correct. They had filed the revision application, my lord, against this order of acceptance. Not, my lord, I had not challenged it. If they had not challenged it.
Initial was challenged by them. Their grievance is that thereafter too, and you have approached the
They can't just say, my lord, that there's been a cakewalk.
Anything, Mr. Chatterjee?
Nothing more, my lord. সেটা তো বলা হয়েছে সেটা no, there's nothing really much more than that. I acted in terms of the court's order. There was not a challenge to the order by which I was given that time to file on that date, not even within. I have complied with that. I have not dragged a proceeding for a single day. No adjournments were taken by me at all. If they had not filed that State Commission, my lord, revision, the matter would have been over by today. It's not for me, my lord, to say before your lordship that
See, you cannot have any grievance against them because they are having orders in their favor starting from State
that's
Commission.
exactly what I'm trying to say, my lord, that
Concurrent finding,
not
my lord,
my-
concurrent finding.
Your filing of this
so
civil
that
division application.
that accusation, my lord, doesn't come into me. That accusation should not have been.
Concurrent finding.
That's not beyond law.
So anything more, Mr. Chatterjee?
And sir, my lord, 21st September 2022 order need not be challenged. It is within just 15 days after the service. Why a prudent person should advise, should challenge it? Not at all necessary.
No, time limit to also. The time was given in this order. 10th November filing was given in that order, not the other order. So this order was the order which
Mr.
says.
Chatterjee, you are not there. Perhaps you have
I-
not been correctly instructed. Your learned friend's submission is that his submission in support of his argument that why 21st of September need not be challenged is that since that 21st of September was within 30 days
But
from the date of
6/9/2022.
service of notice,
Yes, ma'am.
he need not have challenged that. That is his arguments on
My
merit.
answer to that is what I told your lordship. That by this order, my lord, 10th November was fixed. By this order.
So even if
And
from
we
that,
challenge-
my lord, they have traveled
Both
beyond
of you have
45 days.
concluded.
My lord,
So till which time you are present today?
it is always feeling glad that to address your lordship. It
No,
is at that
only
rate.
since you said that you will be leaving today.
Yes, ma'am.
So I will be passing orders today, I think in the
My
second half.
colleague will be there, my lord. My colleague will be there.
So
He practices here only.
tentatively at 3:45.
So grateful,
It
man.
might be here or there some.
So grateful, man. So grateful for the patient hearing.
3:45 সেটা রেখে দেবেন for orders.
Grateful, your lordship.
Thank you.
So
both of
grateful,
you.
my lord.
Yes, call the next matter.
Not in.
No, এটা fixed ছিল না 11:30 না কত? Yes, yes.
In this matter, I am
Where is your other side?
this
Yes, yes. Yes. Have you taken instructions?
I have taken instruction, Malas. I will take just 1 minute. Malas, it will not be possible for me to submit Malas 1 lakh within a day, my lord. If your lordship kindly allows me to pay installment, I can pay installment, or if your lordship kindly fix a certain amount to be paid per month, I can pay per month. If your lordship so directs.
Something you have to pay just now. Something you have to pay as a condition.
When that collapsible gate, they removed it, it cost my lord 30,000.
No, Malas. Malas,
Collapsible gate, they removed.
Malas, it is their allegation, my lord. That
Allegation, photo.
Malas, it is my Malas instruction that Malas, I have did
Damage.
nothing to the Malas gate. They are trying to remove it because they are trying to Malas disposes me. I am trying to repairing it because Malas, Malas, my work is to do to Malas design ornaments. If the collapsible gate is removed, Malas, it will endanger my Malas business.
Photo is saying.
So, Malas, if your lordship so directs, Malas, I can pay something per month or per in this occasion, 10,000 or 20,000, but more than. Or Malas, if your lordship so direct. 10,000 I can pay within a day. Rest 10,000 malas I can pay within a week, and malas per month I can pay 5,000. Malas till the disposal of this application. And if malas if your lordship directs me to give an undertaking, I can malas vacate within 3 months, but malas don't malas the payment of malas occupation charges from the date of the decree may not be malas passed. I can pay the contractual rate of rent for that month. That 3 months I will pay the
Contractual rate 150.
199.
My assumption is more or less correct.
And whereas the application is completely based on misleading statement.
But you have taken instructions with regard to the affidavit for vacating the property.
3 months.
3 months.
3
You
months.
will vacate.
Yes, malas, without malas occupational charges from the date of the decree.
Yes. What is your submission?
First thing, my lord, today, my lord, we have, my lord, deposited, my lord, the police cost, my lord. That is more than 30,000. My lord,
But you will give an undertaking that you will vacate. Please consider that. Have you taken instructions from your client?
Yes, I am agreeable that he will vacate by 3 months. But
By 3 months.
no further damages.
Yes.
My lord, occupational charge.
That affidavit he has to file by tomorrow. That affidavit he has to file by tomorrow.
The event,
No damage, nothing.
in the event they defaulted of today's undertaking, tomorrow later they did nothing, my lord. They choose that tomorrow they will not come before your lordship, my lord, no, without affidavit. So I have to put the police cost again.
Why?
Because the misappeals paid on the second day of hearing. I show from this order that on the
No,
second
why you have to pay the police cost again? Police cost has been deposited.
Yes, it will be forfeited today. Police will come. Police will force will provide it to the building. Otherwise, my lord, if today we missed it, that will be, my lord, forfeited. My lord.
That can be adjusted. That can be adjusted.
Your lord, if
Malas that malas we will vacate within 3 months without damages, malas, but no occupational charges. I will pay contractual rate of rent.
When this matter is pursuant to the
Then maybe it was 10,000, my lord.
No.
Plus I vacate, my lord. Within, I will play, my lord. I will vacate within, my lord, the time period.
You have to.
My lord, I will, yes, my lord, I have.
You are not doing it charity.
Yes, my lord, I will give the undertaking. But my lord, the market rate of then may be reduced, my lord. That is the only prayer, nothing more than that.
Convince him.
Doing
Convince-
business of woodsmith.
My lord,
Convince him.
my lord, I am only, my lord, designing the jewelry. I am not selling it.
7,500. Yes.
13.
Yes.
Lordship, I am for the husband petitioner, Lordship. Lordship, under section 36, Lordship, an interim maintenance of 18,000 was granted by the learned trial court. While Lordship, I am
You are for the husband.
Lordship.
You are challenging. You want to reduce that amount.
Reduce amount because
What are you
Lordship,
doing, Mr. Shanna?
because Lordship, I am already paying Lordship 10,000 Lordship.
What are you doing?
Lordship, I am a Lordship working as a under a Lordship West Bengal Power Development Corporation. Lordship, I am drawing my salary, Lordship. There is several responsibility that was not considered. I have Lordship in my affidavit of asset Lordship.
No responsibility towards the wife, Mr. Shanna.
Yes, Lordship. That's why Lordship I am paying Lordship 10,000. Now in the earlier proceedings, the similar type of
Take back your wife.
Yes, Lordship. I am in the objection, Lordship. I have taken this point that she is not willing to Lordship return to my house. That point has been Lordship taken.
What is your gross salary?
Gross salary Lordship 22-23 is Lordship 81,000 and
81,000, 22-23. So we are in 2025, Mr. Shanna. So it has increased.
But
by leaps and bounds.
But considering that
leaps and bounds.
Yes, but now Lordship, considering that income Lordship, the earlier maintenance was granted Lordship 10,000. Now Lordship, with a similar prayer and similar application without Lordship anything Lordship for extension or enhancing the prayer, there is nothing in the application Lordship which has been filed before the Lordship learned court in the section 36 application. There is no departure from the Lordship earlier application and no
What is the stage of the suit?
Divorce suit has been Lordship stayed after the filing of the divorce suit Lordship filed by the husband.
What is the stage of the suit? Mr. Shanal, you pay, I am expediting the suit.
Issue.
I am expediting the suit by the end of this year. It will be disposed of.
Now, Lordship, maintenance
pay the areas.
15,000 Lordship is Lordship something. Kindly consider I serve and let them show Lordship because in my affidavit assets I have stated that the lady is Lordship lady has Lordship sufficient education. She has an MSc degree holder. Now she has sufficient income, but she suppressed in the Lordship affidavit assets regarding his income.
Why she will work? Why she will work?
Lordship, kindly
When
consider.
you married, you said that you will take all our
Now, Lordship,
responsibilities.
maintenance can be granted Lordship for the luxurious status of the wife. For the maintaining.
Not the luxurious.
Now,
according to your own status.
Own status, Lordship. But kindly consider the point, Lordship, for which Lordship the learned court Lordship granted 80,000, except Lordship the earlier interim order of 18,000.
No. So your income, you said 81,000.
81 after deduction, it is Lordship after 70,000. Now, my
after deduction 70,000. What are the deductions?
Kindly consider Lordship the ordering portion Lordship. It initially Lordship when the interim maintenance under Lordship domestic violence was passed.
So 1/4 of, even if I take 70,000, 1/4 of that.
There is a liability Lordship. Parents is there. Ailing parents Lordship, they are Lordship suffering from.
Have many liabilities. Add one more to those liabilities.
It should be Lordship reduced Lordship something. That's why Lordship I am filing this application because Lordship in the affidavit assets filed by the wife, it is totally suppression of fact. May I
This
serve and-
application under Article 227 of the Constitution.
And parents.
Yes,
is
let's
there.
call the next matter. Yes.
Wait, please, your lordship. Lords. This is a
Yes.
matter which arises out of a custody dispute, right, and which is, my lords, pending before the concerned court. Now, my lords, since 2023, I appear for the father, the husband. Since 2023, there was a very good arrangement that was made by this honorable court that the child will come to Calcutta once because she was born, brought up here, was studying here.
Now where the child
Now
is
she's
now?
in Delhi. Now that's a history which I'll take your lordships why and how she reached Delhi.
Now what is the impugned order?
The impugned order has stopped visitation at Calcutta suddenly without any application from their side seeking any modification of the order passed by this honorable court, because when this honorable court passed a final order, said that parties are obviously at liberty to apply in case there is some emergency or some situation, be that as it may. There is no application for modification from their side, said that visitation should stop at Calcutta. It was taking place. All expenses for that visitation to and fro for the child are being borne by me. The expenses for the wife are being borne by me. She stays in a 5-star property, whichever one she chooses. And for the child, I had taken a flat on rent separately because initially, my lords, your lordships thought that since there has been a hiatus of about 5 years between the father meeting the child, and there are allegations and counter allegations.
What are you doing?
I'm a businessman. I'm settled here. The child was born and brought up here. Child was studying in Lama.
So instead of bringing the child to Calcutta,
Yes.
can you not go to
That
where
was also an
the child is?
arrangement.
Delhi?
That was also an arrangement. No, that was also an arrangement.
Oh, you are appearing for the opposite party. It's on caveat.
On caveat.
All right.
That's the order.
Can I just address?
Order that the father goes to visit him.
Yes.
Lord, the order was very clear. Every alternate month, the child will come here, and the other month, the father would go there to Delhi.
What is
And
the
then
age of the
continue.
child? What is the age of the
About
child?
12 years, about 12, 13 years.
Now,
Would you kindly allow me to make submissions? So this arrangement was already working. It was working fine under the auspices of this honorable court. The court took into cognizance the fact that the child was born and brought up here. She was studying in La Martin School for Girls. When the wife left the matrimonial home due to whatever acrimonious nature of litigation that was there, she took away the child. There was a stay operating by the family court against obtaining transfer of the child from La Martin School. This is as far back as in 2019. Yet, my lords, the child is admitted to some school in Rampur Hat first, then another school in Birbhum by the lady, and without informing any court, that then she admits the child to a school in Delhi, Gurgaon rather, and she's staying in Delhi NCR region. Now, looking to the nature of disputes, matter went twice over to the Honorable Supreme Court, and finally the Honorable Supreme Court directed this Honorable Court to decide the issue of visitation, as also if it is possible for custody. Now, custody issue is pending. It is at the stage of evidence on their side. We are cross-examining the mother. Now, this arrangement was continuing. Now, I can understand, my lords, if there is a formal application from their side seeking modification of an order.
There only one thing. The child is studying in class 7 or class 8?
Class 6.
Class 6.
7 now.
7.
6 or 7. So what was the arrangement? Twice in a month?
No, once a month.
Once a month?
On a Friday evening, she will come, or a Saturday morning to Calcutta. She will stay with the father and go back on Sunday. So that arrangement was continuing very well, my lord. The child was very happy.
It not be the other way around.
No, other way also is happening.
If the father goes.
Father is going, sir.
Now, please think of the welfare of the child. We are not concerned with the father or the mother.
Please.
So only thing is that the welfare of the child. Every month bringing, because the more the days will progress from 6 to 7, class 7 to class 8, he or she will progress. So in a month, 2 or 3 days, I think that might be a difficult
Can I respond to
for
that?
the educational and other what may be the schedule of the child.
I follow that.
Other activities of the child, and it's also strenuous. Every month coming 3 days, then going back, and he or she will return on Sunday. From Monday also the classes will be there. So instead of that, why the father?
No, my lords. It is a, my lords. Madam, please. it is my lords, an alternate month. So it's not as if the father is not going to Delhi. Say, for example, my lord, this month, there is a visitation that would be scheduled. Father would go to Delhi in the same manner. Would go on Friday, meet the child and come back. The next month, the child would come. The reason why it is there is that her paternal grandparents are also here. And the aunt is also here who's unmarried. So it's much better that the court thought that at least some interaction between the grandparents and the aunt
Yes,
and the
that
father.
is also necessary.
No, necessary. Now, my point is this, it is at the stage of their evidence. She is the only witness, maybe another witness.
If I
from
can
their side.
expedite this custody
So
proceeding.
that's already expedited by Honorable Supreme Court. I have no
Yes.
problem in that. That's
Yes.
already expedited. It was continuing almost every week or 10 days. That is why, my lords, it is a slightly shocking exercise of jurisdiction by the learned judge that without an application, I can understand about some formal application being filed so that we have a liberty to file a response. What happens is suddenly when the matter is fixed for recording of a cross-examination, there's a one-line order which says the learned judge would like to meet the child. We object to that for the reason that it is at a crucial stage of evidence. We don't want in any manner the learned court to be prejudiced by, in case, because child has stayed with them now for 6-7 years. There are a whole lot of allegations between the parties, which I'll take if necessary, which are on record. Child is met, my lords, for about 1.5 to 2 minutes in chamber by the learned judge. This is on 27 January. We are not informed of what transpires. The child has also been met for over 2 hours by Honorable Justice Siddharth Roy Chaudhary here in this honorable court. And it is recorded in an order that the child wants that visitation should take place in this fashion, that father should come 1 month and she will come 1 month. And it's a recent order. It's a 2024 order only. It's not very far off. Now, our submission is this. When the custody proceedings itself are coming to almost an end, maybe another 3 months down the line, it would end and finally decide whether I am to get custody or the mother is to get custody. Presently, she has interim custody. What is the need for interfering with a process that was continuing since 2023? Specifically declining their objection that because there are some allegations against the paternal grandparents should not meet. So that objection was rejected by this honorable court while finally disposing of the earlier CO. That no, the grandparents should meet. Now, that part, that without an application, without any formal order, without any formal application, without any opportunity to us, so it was my application saying that now that the Honorable High Court has allowed the child to stay at my original residence, where I'm staying with my parents. So why should I continue with a property which I've taken on lease? Because as I told your lordship, initially this honorable court in the proceedings was of the view that take a separate flat, meet the child there, let the interaction begin. It stopped for 5 years, let the interaction begin. And then slowly perhaps things will improve. So things were improving, but not the child wants to meet the father. The child wants to meet the grandparents also. That arrangement, if it is continuing, and another 3 months' time, my lord, the petition itself would have been decided. What was the grave urgency suddenly, my lords, to modify the order passed by this honorable court and close the visitation at Calcutta completely? Now, my lord, this puts because for Delhi, my lord, the grandparents are not allowed. The Delhi order is that only the father can go. So it was only this little window that the grandparents had, my lords. Since the child was here, my lord, till about
No, if the grandparents want to go to Delhi, so that can be arranged.
Vacations are with the grandparents.
No, we are not on vacations.
Vacations, 28 days in summer and 14 days in winter, because that's the holiday. In Delhi, you get 2 months summer.
Yes.
It's an international school, and 1 month in winter. So the honorable court has said, which we are following. Last year also we followed 28 days in Calcutta and 14 days.
No, that is
That but not part of summer vacation, winter vacation, something completely different. That is
to come every
just one second. No, there is no harassment to the child per se, not with great respect. According to me, it's my respectful submission, subject to what your lordships may feel. Children, my lords, till at least class 8 or 9 are extremely resilient. 10th onwards, I know boards, etc. would come.
Nowadays,
I know, my lord.
They start.
No, I follow.
Hearing from class 7 itself.
I'm not saying that, my lords. All that I'm respectfully beseeching your lordship is with this. If the main custody fight between the parents, which is acrimonious, is going to end in another 3-4 months from now, maybe another line from your lordship's order to expedite it further, even though there is a direction by
There
Honorable
is an
Supreme
order passed by the Honorable Supreme
It's
Court.
not required per
think
se.
It's not.
So
to
there,
add.
my lords, why would just one?
File, there is a order, my lord.
No, so there was no application for modification.
No, my lord, there is, you do file no application.
He's incorrect. My lord, I'll file my reply. I'll show my application. Only
is-
on my application, the
No,
honorable.
my lord, I
judge
think, my lord,
let
let us be,
child-
my lord, let us be correct on facts.
My lord, I have my application. Which
No,
was-
you may have. I am not saying you not have.
Also, my lord.
So let us, my lord, can I read the impugned order for your lordship?
Reply, my lord. All this will be clear. Can I file a reply? You can give a short date.
No, can I read the impugned order, my lords? It was my application which was being adjudicated upon.
My lord, the
Just 1
judge
minute, ma'am,
met the child on my application.
Ma'am, I don't understand why this running commentary begins. My lord, 20th of March is the impugned order, lordship has it. 20th of March 25,
Yes,
order
yes,
number
yes,
88.
yes.
Can I read that, my lords? The record is taken up for passing order in connection with the 3 applications filed by the petitioner father on 22nd January 25, 27 January 25 and 28 January 25. I have heard the learned advocates for both the parties at length on the previous date. The respondent mother did not put in any written objection against any of the 3 applications. The first application has been filed with a prayer permitting the petitioner to terminate the lease deed for property bearing number so-and-so, Paramount Apartment, Ballygun so-and-so, and allow the child to stay at the residence of the petitioner and her grandparents at 60 whatever Ballygun Circular Road during the visitation in Kolkata. It is contended on behalf of the petitioner that the flat taken on rent is used only for 2 days every alternate month during visitation, and if the court permits the child to stay with the petitioner and his parents, the paternal grandparents, it would spare the petitioner an excess burden of 76,000 which he has to incur as rent for the flat. The petitioner has also added that the petitioner has paid the arrear maintenance amount of 19 lakhs to
Show
the
me this
respondent.
application of yours.
Yes, my lords. That application of mine is, my lords, in the paper book at page please come to annexure, my lords, L, page 461. No, this is the other application. I'm sorry.
No, this is urgent.
No, this is
interim
another.
direction.
I'll give the page, my lord. I'll just give the page to your lordship. Give me the page number of that application. 461. No. Termination of the lease deed. Lords, I'm sorry, that application is only seeking termination of the lease deed.
Where is
Yes,
that
yes, Lord, that application
is not here.
Is not here, my lord.
Bring the application.
We'll bring the application. Termination.
Application. Which order disposes of your application?
None.
in this order, which
None.
is my Justice Nilanjana Chatterjee's 20th March 2025 order.
Yes,
which
which
is-
order? There are three numbers of orders. Which order?
Yes, so what she did is, on the 20th, on the 20th and 21st of January, she met the child on my application, right? And then when this order
Show me from the impugned order which refers your where.
it would be in this order, it's in the earlier order, because in
So not by these orders.
this order happened after
a different
she had met the child.
Always.
It is their
That is a
application is
different
on
thing
record. I'm sorry.
So
Application.
that is not
No, application is on record. 438.
438. Yes.
Yes, please come to 443.
Yes. 438.
At 443, the prayer.
Yes.
I'm sorry, my lord. It's got a little mixed up. (438) it begins, and please turn to page 443. Then annexure H, your lordship has it.
Yes.
Now please come to page 443, my lords. What is my prayer in the application?
Yes, I've seen that.
It is only to terminate, my lord. That's all.
Yes.
Now, while considering that, I'll be fair to my learned friend. While considering this application, they never filed a reply to any of the three applications. The other two are also very serious, but I'll touch upon them a little later. But on this application also, they did not file any reply. All that they orally said was, you have met the child in chamber, the child has a problem in coming to Calcutta. And then comes the impugned order on 20th of March 2025, which my lordship will permit me to read.
Yes.
In paragraph, on the very first page, it records my prayer. The first application dated 26, the third paragraph, my lords, on that page.
So the trouble started since you wanted to terminate the lease.
For the reason, my lords, that I was saying.
Are you willing to continue with that lease?
We have terminated that lease presently because we have got an order of seeking termination. They also didn't oppose termination. And the reason was this: I was, my lord, keeping the flat as a white elephant for only 2 days in every alternate month, paying 76,000. And my lord, there is a huge expenditure, which of course I can afford. So therefore, I'm taking care of my child. I'm taking care of the wife. That part is separate. Today, the lease is not there. Lordship so directs, we can take another flat on rent for continuation of visitation at Calcutta. Our submission was, once this honorable court has allowed the child to stay with the father and his parents during the course of summer vacation and my lord's other points at Calcutta, to bring a child for 2 days here, keep her for 1 day in one house and keep her from another day in another house is causing trouble. It should not happen, because as your lordship fell from my lords, for the welfare of the child, why should we keep, my lord, shunting her from one, as it is, she is coming from Delhi. So why should we keep shunting now within Calcutta also from one house to another house? So let me stop this lease. The other house is also almost adjacent to the this property. I'll stop paying rent. I'll terminate the lease, and the child can come and stay with me. Alternatively, my lords, if your lordship wants, let her come here. If they have any objection, we'll take my lords 1 day or 2 days, whatever accommodation is there in any good hotel that she is used to staying. Because in Delhi also, I don't meet her at their house. I have to take some place either in Hyatt Regency Delhi or whichever hotel is not suitable to the child, looking to her schedule. So I can take a hotel also. That is also not a problem. At least, my lord, the grandparents can get a glimpse of the child. That is the reason. Now, my lord, I could have understood if they had a formal application to which I had got an opportunity
Yes,
to
but
respond.
what is your objection if
My lord, he's finished.
this arrangement in a separate flat was continuing for this long?
My lord, it has nothing to do with the flat. I don't mind if he has a flat. I don't mind a hotel. I had filed a formal application on the request of the child. She had called me up. She's now 12 years old, very articulate. She goes to a good IB school from the age of 5. When I first got the case, my lord, it was just after COVID. That time she was small. She was about 8 years old. And she has been harassed, my lord, from 23 onwards, when Honorable Justice Rochaudhury's order came. It was presumed by my lord that it will finish quickly. You know, he sent back the matter. They had come to the Honorable Court against the order of the lower court, by which interim custody was not granted. They had come. The honorable judges naturally thought within 1 or 2 years it will be over. She had not seen the father. In fact, when I first came into the case, my learned friend, Mr.
When did the child last come to Calcutta?
My lord, this 2 months ago. So now what is
So 2 months, till 2 months
Oh,
ago,
my lord,
he came.
to meet the judge, to meet the honorable judge.
No, to meet the father and the.
Same month.
So at that point of time, she came. She met.
My lord, that is what was happening. That every time, just think, my lord, the child is 12 years old. She goes to a school in Gurgaon. She has her homework. She has extracurricular classes. I have made a list of dates, my lord, which will help. 14 times, my lord, 14 times on every I'll give you a copy.
Madam, please show me the order, the application by virtue of which this order was passed.
There were 3 applications filed by him.
By them. So there was no application at your instance
I'll show
for modification of the earlier order of visitation.
There was, my lord, my application.
Where
has
is the order
been-
passed?
That was the earlier order. I've got it.
Show me that.
Yes, sir. My lord may see this order.
A single line order to meet the child suddenly out of the blue.
Judge's order. my lord.
That's all right.
Litigation.
I'm not saying anything against the judge, but it's a single line order. Suddenly, my lords, it's fixed for respondent evidence. The learned judge says, I'd like to meet the child. We record our objection. And we record it with due deference, my lords, and complete decorum.
For 45 minutes, the learned judge has met the child.
So sorry, less
The
than
child
15.
has complained completely that she's harassed.
360.
My lord may meet the child.
360.
Where is the order dated 6th of February 2025?
I have just before the, I'll give you. I have,
The next order, next order.
I have all the orders of the court. This is a complete set, my lord, chronologically. I've got a list of dates also.
But please take it from me. There is no application from their side seeking any modification.
Lord, I'll give it on affidavit. My application is here, the filed one. It's signed by his.
No, this order of 22nd of January records there is an application for modification.
And it's signed.
Modification. Of
Signed COR, my lord.
Madam, why are you shouting?
Sorry, I don't understand.
Now we are having the microphone. Please don't strain your voice.
6th of February.
22nd of January.
That is my application.
No. Respondent.
Yes,
Who is the respondent? In that.
The wife.
Act 8A,
They are the respondent there, yes.
Respondent files a petition.
Yes.
Sorry, the petitioner files an application paying for. So the petitioner is.
It's my, just 1 second, let us not confuse issue.
Please.
My lord, there are 3 applications. Yes, I'll see.
No, this 22nd of January.
My lord, December I filed.
This is my application, my lord. See, I am the petitioner there.
Yes.
I am seeking custody of my child.
Yes.
So my first application of 22nd January.
Madam, where is your application? Which order records your application for modification? That order is his application for modification. Show me which order records your application for modification.
Yes. This is my application, my lord, which was filed.
Show me the order recording that you have filed an application for modification and how it was dealt with.
Yes, my lord. So, my lord, when I filed.
Show me the order, madam, first.
Not the impugned order itself records everything. Yes, very well.
My lord, in December I filed.
Show me the order recording and how it was disposed of.
Yes. My lord, may kindly pass it over. I'll take out that order. And
Madam, I will hear this. Apparently, there is no application for modification. Does not record.
it is.
Show me the order recording. Madam, please show me an order recording modification of the earlier order. Show me that.
My lord, in the last order, which is the 20th March order.
Yes.
After meeting the child
Yes.
for 2 hours in January.
Yes.
The learned judge has passed this. And what was the reason? What she has given a reason that it is the
Madam,
child.
Can you show me the order modifying?
I'll get that order.
Lord,
Lord,
there
can
is-
I file my reply with the affidavit with
You
that?
file your reply. In the meantime, I am saying this.
No, my lord.
I am deeply obliged.
Lord, just one thing.
Has
One
to
thing, my lord. Please, kindly. The child, after all, ultimately now there's.
I will consider your submission.
My lord.
Please show me an application for modification of the earlier order of visitation.
Application with me.
Uh,
Just
the-
because, my lord, the learned judge, because she was going to grant my relief, she did not refer to this. The child cannot be prejudiced, my lord.
Please.
My lord,
On,
There is-
on 28th, I will,
yes,
because the next date is on, for
point
visitation
is
of
not that,
13th
but
of May.
the last visitation took place in January
Yes.
in
No,
Calcutta.
you said 13th of May is the next
Yes.
date of
True,
visitation.
10th
true.
and 11th,
I'm
my
not
lord. 10th,
concerned.
11th May.
Madam, could you kindly just permit me to make my submission? Every day we have the same issue. Now, my lord, all that I'm respectfully submitting is the grandparents and the father last met in Calcutta in January. February, the father went. March is this order. She was supposed to come here. April was my turn to go. Since the same order permits me to go to Delhi, we did not utilize that opportunity so that not our CO doesn't get prejudiced. All that I'm respectfully submitting is this month, April. at least allow that visitation to happen at Kolkata.
28th is Monday.
Very well, very
Today
well.
we are on
very well,
Wednesday.
Very well, very well.
Obliged,
sir.
madam.
Deeply obliged. Certified.
কোনটা?
মাই লর্ড আমার ফাইলটা 17 নম্বর কোর্টে রয়েছে, আপনি রিকুইজিশন দিয়ে দিলে ওখান থেকে বলছে
ঠিক
দিয়ে
আছে।
দেবে। তাহলে
Yes, call the matter.
হ্যাঁ
ঠিক আছে। Item number 7, এটা তৈরি করো।
Lord, I am appearing for the petitioner.
Well, I first tender my apology, my lord. I was not aware of this, my lord. My lord,
What
may
has-
I just say this, my lord? My lord, kindly give the time till tomorrow 10:30.
That is why I was going to pass an order. Thereafter, I
No,
stopped.
no, no, I will not. I will also summon upon the police officer why he has done
For
this.
that,
For that.
for that.
Let him
because-
come tomorrow with the Pradhan and then my lord, I'll
So I'm not recording anything.
my lord, just
I'm
because
only
that I am,
adjourning it on your prayer till tomorrow.
my lord says that I have
Lord,
sought
kindly
for
pass
that.
an order, my lord. Lord,
Ashul.
Here on behalf of the OPs, my lord.
You are appearing on behalf of
the opposite party, my lord.
Yes, yes.
That matter
That is
yesterday.
that matter. Yes, Mr. Bonik, what is
The
your
lordship
instruction?
was last occasion yesterday was asking that whether the amount of rupees 19,000 which has been asserted by us in my application, something is there. You know, two applications 7-1 has been filed. In one application, we have categorically stated that some amount is due on and from the month of August 2021 and may be permitted to deposit the current rent month by month. And another application on the same date, we prayed for payment of 19,000. So if you take both the application together as a one application under 7-1, the direction was made to pay the amount month by month. Your lordship, kindly have a look to the
Mr.
order.
Bonik, even if that is so, under the statute, you are an obligation to pay the admitted arrears within 1 month. If you have not paid, Mr. Bonik,
Your lordship, kindly
7-3 automatically.
Your lordship will pass the order. My lord, kindly, for my lord satisfaction, your lordship kindly sees the order.
Which order?
Order dated 24th of March 2023. Order number 9. Yeah,
24th of March.
order number 9, 24th of March.
Order number 9. Yes.
Record is put up today by put up petition filed by the defendant. Defendant appeared by Vokaratnama along with 7172 WPT Act. Copy served. Hard learned advocate of the defendant with regard to petition. The petition under section 7(1) of the WPT Act filed by the defendant is hereby considered and allowed, but at the risk of the defendant. Defendant is hereby permitted to deposit the current rent month by month as prayed for in the court by challenge. So our prayer was, the prayer of the tenant was in twofold. One is I may be permitted to deposit the court fees, current rent month by month to the court, and also the area amount of rent 19,000.
Where is the other application? One application 19,000 is here.
Yes.
Where is the other application?
The first one.
Where is that?
My lord, page 11. 1-1.
Oh, page 11. Yes.
To make deposit amount monthly rent firstly from the month of August 2021 to
Yes.
till now, and thereafter month to month.
But Mr. Bonik, this amount, so there are two things.
Two things.
There is no dispute with regard to the rate of rent.
No dispute.
So according to you, your admission is default since August 2021 till March of 2023.
And that is to be that has been calculated at 19,000.
19,000. So nothing is in dispute.
Nothing is dispute.
So in this you prayed for time to first deposit that and thereafter to continue to pay month by month. That prayer of yours was allowed. So
my lord,
maybe you have deposited month by month, but if you have not deposited
the prayer, the order reflects that defendant is hereby allowed to deposit the current rent month by month.
There are
Lordship, your lordship,
I have seen that, Mr. Boni.
If that
when
is
you are
so,
reading, I have seen that.
If that be so, my lord.
And your prayer was allowed. Your prayer was twofold to deposit from August 21 to May as well as on current.
The prayer was allowed, but the ordering portion is this.
Mr.
Prayer is allowed. Your lordship knows in case of
Boni,
passing
that
order.
was at your own risk. Under the statute, you are under obligation. This was an admitted amount. You ought to have deposited.
Your lordship, this application has not been heard. 7-1-7-2 has not.
7-1, there is no requirement to file any application.
No direct.
There was no necessity to hear also.
No.
There's no requirement under the statute to file any application.
Ultimately, since I have not been given opportunity to show the deposit challenge. Challenge I have filed. The learned trial judge did not see the challenge.
Neither here nor there. So if the initial is not there, even if you deposit, even assuming that you have deposited the other amount, but the fact remains from
August been decided by the learned trial court. If your lordship will take this point,
Mr. Bonik, show me that you have deposited
I
that
have
19,000 from August 2021 till March 2020. Show me.
My respect to submission, Lord, I cannot go beyond my case. This is the direction made by the learned trial judge that you have to deposit as per your prayer. You are hereby permitted to deposit the rent month by month before the court So that is why I have started my depositing rent, my lord, which is appearing from page 27 onwards. My lord, your lordship kindly have looked to page 27 once.
27, yes.
I appeared.
Yes, yes.
On
Thereafter,
24th
you have
of March.
deposited. There is no
Yes.
dispute with regard to that.
24th March order was passed. I appeared, and thereafter 19th of April within the stipulated period of time.
But
as per,
from August to March, you have not
it is 2
deposited.
minutes, but that there is no direction on that. Your lordship kindly
A direction under section
Kindly
7(1),
consider also you have
deposit is not at
deposited.
all required. The statute is clear. Once he appears before the court, he admits an amount. He has to, on his own motion, go and deposit the amount with a 10% interest. He does not deposit. An order is not required. The statute gives the option to go and deposit in the court or to pay to the landlord. He does not do anything. He quantifies and he says that this is the amount, 19,000 odd is the sum which is due, and he should have gone and deposited that amount. Yesterday he said, we will see that whether we have made this deposit or not.
Mr. Bonik, page 20, this April rent you have deposited when? May 2022. So these were deposited.
Yes, we deposited.
So these are the rent control challans.
And rent control challans. These
Not
are the
before
rent
the
control
court.
challans. That is why 7-2.
I know.
And this required to be adjudicated. Originally, the rent has been deposited. That is not the fact that rent has not been deposited. Only the challenge has not been shown to the learned judge. That is why this order has been passed.
Yes, Mr. Dotto, this amounts have been deposited before the rent controller. So that was prior to service of summons. So prior to service of summons, he was entitled to deposit before the rent controller.
Kindly see
These are to be taken
what he was required to do before the court, my lord. He was supposed to deposit the admitted area rents. He admits that he has made there was a default admitted areas from August 2021 till February 2022.
From August 2021.
It's true, my lord, but
Yeah, that's
kindly see the order passed, my lord. I will not go beyond the order, my lord. We cannot. Your lordship kindly sees the order number 9, 24th of March 2023. That is the specific order.
Kindly take the provision of law.
14th of May, my lord, I did not appear because my client was ill. I did not appear before the court. Client was ill. I prayed. I sought time before the court. Since my client is not able to come before the court, I deposit the challenge. That application.
Where is your application under 7.2?
That's
page.
Your lordship will kindly come to 7.1 is 11 and 7.2 is 14.
14. 1-4.
Page 14. Kindly come to page 14.
Lordship kindly sees the prayer, whether the defendant is defaulted in payment of rent. So this prayer was made by the tenant.
Yes, Mr. Dotto, let the trial judge decide all this. Consider the
kindly see page 18. Kindly see page 18.
Consider the challans and pass an order.
Kindly see page 18.
Default is the defaulter. Let these challans be considered.
Kindly first. Kindly. Malur, kindly see page 18.
Yes.
He says in page 5, paragraph
18.
5, that
It's,
this is the amount that is due.
Page 18, but it's also the application under section 7.2. He has said for some months you have accepted. There are rent control challans which have been annexed.
And deposited
And
as
now,
Control
your
challans
lordship
which
is
have also
kind,
been annexed, which is to be has to be adjudicated.
kindly come to section 7 once.
Yes,
Kindly come to section 7.
yes.
It's his obligation. Once a suit is instituted and he appears, it's an obligation of the tenant to go and deposit in the court the admitted amount or to the pay to the landlord. He admits this is the amount which is due and arrears. It's his obligation to go and deposit it. He quantifies the amount, that this is the amount which is due. He says this is the amount rate of interest that is required to be paid. He does not take shelter of those rent control challans, saying that I have deposited
at the rate at which it was last paid.
Amounts before the rent controller. So those amounts should be excluded. And
Yes.
this is the amount which is arrears.
Mr. Dotto, your voice is breaking.
That is the amount which he admits. He doesn't take shelters of those rent control challans.
Yes.
If today is a new case which he is running, because on the before the learned trial court, he says that this is the amount is the arrears and kindly permit me to deposit with a 10% as per the statute.
Rent
No,
control.
that is why your lordship kindly see the prayer of 7. Yes. Your lordship kindly see the prayer of 7.
Yes.
I said that this is the due and payable August 2021. This is as per my calculation, and 7.2 I have prayed. Your Honor, kindly have a look to the prayer of
And
7.2.
the prayer of kindly 18, the prayer says,
Your Honor,
kindly permit me to deposit the area amount rent of rupees 19,000 in the above
month by
suit.
month,
Allow
upon
me.
determination of dispute. If the learned court be pleased to find that the defendant is defaulter in the payment of monthly rent for any month or months, such amount or area rent may be directed to be liquidated.
My lord,
Thereafter, this direction was passed on for 24th of March 2023 that you have to pay the amount of rent month by month, and according to that, I have started paying the amount.
my lord, since there's a
Fine.
Mr. Dotto's side, may I kindly point out one thing, my lord? My lord, kindly
Who will argue, Mr. Dotto, or you will argue?
My lord, I am being led by Mr. Dotto, but he is inaudible. That is why I want.
Then please come tomorrow, not today. Yes.
Lord, on one thing, Lord, tomorrow is the date, last chance. Otherwise, the
Will
cross
appear
will be
tomorrow.
happening. Your Lordship, kindly, only tomorrow, only, Lord, protect me for tomorrow.
Tomorrow nothing will happen.
No, this is last. Order down.
Heard Mr. Bonik, learned advocate for the petitioner. Mr. Dotto, learned advocate, appears through virtual mode, but due to some technical glitches, he is not audible. In view thereof, list this matter tomorrow under the same heading.
Your Lordship, kindly protect me tomorrow. This is the date fixed in the city.
Tomorrow we will seek for an adjournment. Since my lord is hearing
Otherwise, the
matter, we will seek for an adjournment if it is not heard.
Learned court.
That my learned friend be rest assured.
It has been submitted by the learned advocate for the opposite party that they will not oppose the prayer for adjournment before the learned trial judge. Tomorrow.
Great.
This matter tomorrow ta bolechi to? Yes, next.
134.
Has come up with your lordship for your lordship's kind consideration, because the evidence of the defendant was closed on the ground that on the ground of
You are for the petitioner.
and for the petitioner defendant that I was not allowed to depose because I sought for time on two grounds, on the grounds of illness. But that the examination chief started and I diligently the cross-examine. So examination chief started not on
Arguments completed.
kindly see, this is the order. I prayed for adjournment, that we prayed for that. The matter is pending before the honorable court. Kindly adjourn. this learned trial court pressed upon this.
No, that was on 27th of February. What happened on 27th of February?
Same is that I prayed for time, that the order time was not given. Subsequently, this is also 3rd of April. 3rd of April also
What is the next date fixed?
29th for judgment. But I earnestly requested on a trial judge to give me a chance so that I can.
By the order impugned, the
I beg to
no, 36.
137, Your Lordship. I had
37, 6 no.
137. It was my mistake, Your Lordship. My lord,
Yes.
an amendment application was rejected only because it was filed at a belated stage. By the amendment, I wanted to incorporate subsequent events. My lord, kindly takes up the schedule of the amendment, page 22, Your Lordship. 1 to 5 are absolutely formal in nature, Your Lordship. 6A is the portion which I want to incorporate.
What is the suit for?
Suit for eviction and recovery of khas possession under the premises transfer of property act, Your Lordship.
What is the subsequent event?
The suit property is under lock and key due to the rains. It has been waterlogged. The suit property is being constantly damaged. It is further submitted that
No, you are the plaintiff.
I am the plaintiff.
Why are you trying to delay your suit? Why it is necessary? He is damaging and other things.
My lord, this suit is
Suit under the on the ground of
MOP, Your Lordship.
MOP,
MOP, Your Lordship.
not 106.
No, Your Lordship. My lord, kindly takes up the plaintiff. Paragraph 5 onwards, Your Lordship, page 14.
Landlord plaintiff, you are trying to change by inducting landlord. So the question of
I am one of the. My lord, I have stated in paragraph
which
3, Your
paragraph
Lordship.
deals with your allegation of MOP?
Your Lordship, 5 onwards, paragraph 5 onwards. The plaintiff further submits that the defendant and or his alleged agents and relations are guilty of committing acts
Yes,
of
where is your
damage.
amendment application with regard to MOP?
Amendment application starts at page 21, Your Lordship. The amendment sought to be carried out is at page 22.
You are trying to delay your own suit. What can be done? Ashun, this application. Yes.
My lord, in this matter, I am for the petitioner, my lord, led by Mr. Shomu Mujumdar and Mr. Patrulatim Rai, my lord.
Yes.
My lord, in connection with this
The
proceeding, my
Patrapati Rai is not available.
today
in
is
town.
not available, out of town. That I should be candid before your lordship, he is not available. But
Yes,
Mr.
yes.
Mujumdar is there, my lord. May I pray for short passover, my lord?
No, please start. Yes.
My lord,
Yes, yes. What are you praying for?
my lord, this is for expedition, this disposal of matrimonial suit, my lord. I am for the husband petitioner, my lord. My lord, in connection with this proceeding, an earlier one civil divisional application was filed, my lord, and that is pending, my lord. May I indicate?
Since I'm not inclined to take up this.
My lord.
I beg to appear for the petitioner. This is my application for expeditious disposal, my lord. Suit for partition, declaration, and injunction pending before Learned Civil Judge, Senior Division, Second Court at Howrah. Suit was filed back in April 5th, 2019. The suit is yet to see the light of trial. Two interlocutory applications, one in the nature of 3912 at behest of the defendant.
So order 39 rule 1 and 2 at the behest of the defendant.
Defendant, my lord.
And order 39 rule 7
39(7)
at the behest of the plaintiff.
Plaintiff.
These two applications are pending.
My lord. My lord.
What is the next date fixed?
My lord, the next date is fixed for hearing of 3912 application, my lord.
When?
My lord, the next date is 29/7/2025, my lord.
And order 39 rule 7?
That is not on the board yet because of the pendency of 3912.
No. 10th of April it was fixed. Both the applications were fixed. What are you saying?
My lord, kindly
What happened
takes
on
up
10th of
the,
April?
my lord, kindly takes up, my lord, subject to correction. My lord, kindly takes up the last order. My lord, I stand corrected, my lord, I stand corrected, my lord. Both of them, my lord, I stand corrected, my lord. I tender my unconditional apology, my lord.
Awesome. So both the applications have been fixed.
Defendant one is the petitioner.
Yes.
Defendant number one is the petitioner sued for declaration that the plaintiff is the owner of acidual property, which is 3 decimal, and injunction not to disturb their possession. Not the impugned order by which 151 application has been allowed.
What is the 151?
Not for police help, for implementation of an order of ad interim injunction. Now, my lord, none of our points in the objection which we have taken has been dealt with, even touched by the learned judge. But his case is that his name was, but he says that Khuderjan Bibi was the owner. From there, Hasina Bibi, his mother, became the owner, mother gifted. Now, my lord, he relied on a ROR. That ROR has been changed and his name.
Where is the order of ad interim order of injunction?
Lord, your lordship will get that note ad interim order of injunction at page
Is there any
37.
caveat?
No, there is no caveat. Page 37.
Page
Defendants 37. Defendants restrains from disturbing the peaceful possession of the plaintiff upon the acidual property. He is not even in possession. Our case is that there is no attempt at all. He is not in possession. Nothing has been dealt with.
So who is not in possession?
The plaintiff. They relied on an ROR. That has been altered. Their name has been deleted. That was produced before the court below.
So this ad interim order of injunction was passed on
Yes. Now what happened thereafter? We
on 11th of April
2023.
What happened after that to the temporary injunction?
I tell you, sir. Temporary injunction is pending. We filed objection. We filed written statement. We also filed a 39-4 that has been rejected on the ground that not the injunction shall be heard. My lord may have a look at that order also. But today, kindly take the impugned order. None of the points agitated by us, my lord, has been considered. Our written objection, I will get note at page 72. Kindly take once.
Written objection to the police cell.
To the police cell. Kindly only take note 3 paragraphs. See what are the take paragraph 25 onwards. See 25, we have said that their name has been deleted from the ROR. They relied on a forged deed of 1963. Lord, we filed 156.3. The magistrate has, Lord, after preliminary inquiry, directed for registration of FIR. That point was also taken. Lord, deletion of the name of the ROR, my lord will kindly take the BLR's order at page 111. Para 25.
According to you, you are in possession.
Yes. Lord, kindly take paragraph 100 at page 111 once. See why it was deleted from 112. So, similar net match 112. Plaintiff's mother's name. They relied on the ROR in paragraph 6 of the plaint. The injunction is with regard to possession only. And after the injunction, after we filed a WS, they prayed for an amendment, filed an application for amendment of the plaint and injunction, describing their case, explaining their case, because that case,
By Your application will be decided, Mr. Chakravarti.
Yes, yes.
Yes, madam. Suit may be dismissed in the meantime. Can point out order 7, rule 11, other things. Suit is not maintainable.
I'll stay the suit.
Frivolous suit.
Till
Get the
such
suit
time.
dismissed, Mr.
Till
Chakravarti.
such time, stay the suit. Not otherwise, police will, they are not in possession, they will go and take over
Yes,
possession.
yes, the next matter.
But I am for the petitioner, my lord, the prayer for expeditious disposal of the proceeding.
Of
This
what?
matter is pending since 2020. So I am for the petitioner husband, the suit for divorce is pending since 2020. Kindly cease the series of order sheet. Unnecessary taking adjournment by the wife for only the ground that for filing WSW. Even the matter was ended in ex parte by the learned
What
court.
happened to the application under section 36?
Only, my lord, after a lapse of 3 years, they have filed a
All right, let it
section
be
36.
disposed of first.
We
It has to
want
be
dispose
disposed
of the
of
matter.
first.
Yes, we want to
This
dispose.
application
The
under
entire matter
section
should be disposed of.
This application.
So
under
after a
Article
lapse of 3 years,
27 of the Yes.
Lordship, I appear for the petitioner. Lordship, this is my application from an order of dismissal of an application under Order 7, Rule 10, Lordship. Lordship, what has happened is, this is a commercial suit which has inadvertently been filed before the regular civil judge in Alipur. So, Lordship, the transaction between the parties are that my client, she's a petrol pump, she runs a petrol pump. And the defendants, they do in the business of tours and travels. They had an agreement that they will that we will be supplying them fuel on a monthly basis. We will be raising invoices. They will take fuel on credit and they shall pay us on a monthly basis. Lordship, they have been in default. The suit value is more than 35 lakh rupees. As per the Commercial Courts Act, the Lordship, this is a commercial transaction and ought to be tried by the learned commercial judge at Alipur. So we had preferred an application. The application has been dismissed, Lordship. The order is at page 121 of the application, Lordship. My Lord will kindly see page 124 where the finding of the court has been arrived at.
You have the Commercial Courts Act.
Yes, Lordship. If I may hand over, Lordship. Lordship will kindly see section 21C1 and
All right, I have
280.
I've got. Under which clause?
Lordship, under 21C1 and
21C1.
21C1 and 21C18, Lordship. 21C1 says ordinary transactions of merchants, bankers, financiers, and traders. Lordship, I fall under the traders category, such as those relating to mercantile documents, including. Yes, Lordship, I am a petrol trader. And Lordship,
Whom is the dispute between you and?
Between me and a tours and travel agency, Lordship.
You have an agreement to supply.
Lordship, it was an oral agreement. The mercantile document here is the invoices raised by me. Lordship, though there is no formal agreement, but it's a general principle under the Commercial Courts Act that any transactions entered into between.
By the order impugned the application and
Yeah,
21, my lord, I am for the petition. In this matter, my lord, I am led by Mr. Protindra Narayan Rai. He is not keeping well. I am seeking an adjournment for this week, my
on
lord.
the prayer of the learned advocate for the petitioner hearing of the matter.
Order first by the net. Yes. Miscellaneous appeal, Lord. Thereby affirming the order of injunction passed by the Garnet Trial Court for declaration and injunction. So what happened, my lord, in this case? The,
Mr. Ghosh, please use the microphone.
yes.
Yes.
But the property originally belonged to the original Khotiar number, original bank number 77. Originally belonged to, my lord, 3 sets of parties that they are amicably partitioned and 3 separate.
The courts have passed an order of injunction.
Yes, my lord, though in the plaint itself it appears that they are not in possession. And my lord, as soon as it was noticed that the record of right is erroneous, he applied before the PLRO miscellaneous case was started. After service of notice, they appeared. There was an inquiry, and the inquiry report that though it has been recorded in their name, but they are not in possession. Surreptitiously filed the suit and got an order of injunction. Therefore, in spite of our taking specific plea that it has been before the authority concerned, the learned court will have not taken into consideration, and from the affirmation of the plaint also it will appear.
Where is the order of the trial court?
The trial court order, Lord, your lordship kindly see that at the relevant time we could not collect the trial court order. Your lordship kindly take the certified copy. We shall teach it, Lord. But ये बोकर मत करके ट्रायल के ऑर्डर चाहिए नहीं.
Ad interim order, I think you have not filed the ad interim, the trial court's order. What was the ad interim order?
See, ad interim order has been made absolute. That is this.
Yes, yes. What was the ad interim? That is why I want to
Not to
now
change-
see the ad interim.
not to
Temporary
change-
injunction says ad interim made absolute,
Yes.
but it has not been stated what was the ad interim order.
Lord, I'm telling. Not to interfere with the position.
Where is that?
Lord, I'm telling you. Ad interim order injunction कहाँ है? Just a minute.
Uh,
The fact lordship kindly take it we have the listed motion, Lord, otherwise.
Mr. Ghosh,
We have been suffering, Lord. We are in position, they are interfering. They have admitted that we are in position in the plain paragraph 8.
Application, maybe Mr. Ghosh, keep a watch on the list. Contested applications may be disposed of very expeditiously.
Lord,
Yes.
one thing, Lord. Lord, item number 10 and 11, I could not appear. Your lordship passed it over. I had a talk with Mr.
Tomorrow?
Mahatma tomorrow. Okay? Lord, he asked his that difficulty. That's
Yes, yes. Yes, call the next matter.
23.
For the petitioner, petitioner is a defendant in a suit for eviction of licensee. The petitioner has an independent suit.
Petitioner has.
Is a defendant instruction to appear on behalf of the opposite party.
Why did not lodge a caveat, Mr. Aldar?
Caveat was lost.
You have received the instructions, but you have not filed the caveat. Do you have a right to oppose without filing any caveat? Then let me hear Mr. Banerjee then.
Let a copy be served and kindly takes it out next week.
Why did not file the caveat? When did you receive instructions?
Yesterday.
You have chosen not to file, only to keep a watch on the list. When it will appear, in the list will appear. Mr. Banerjee, give him a copy. When this matter is taken up for hearing, Mr. Haldal, honored advocate, appears for the opposite party.
For all of them, though. Whether he's appearing for all the opposite parties, because there are not four.
Mr. Haldal, for whom? All the opposite parties.
1 and 2.
Then
1 and 2.
How many plaintiffs are there? Other plaintiffs will be represented by other advocates.
All of them. All of them.
Say so. Or you will say some other plaintiffs will be represented by other
By
advocates.
name, I know the 2 persons. That is the.
No, sir, actually, the same plaintiffs.
Yes, yes. Yes, call the next matter.
So next week, Monday.
Next week, Monday. Monday motion. Yes.
24.
My lord, I am opposing this application, my lord. I am on caveat, my lord.
Yes. Yes.
My lord, I take the point of, my lord, maintainability. I wouldn't say, my lord, there is an action challenging an order of the surface under surface by the DRT.
My lord, interesting point. I'll tell you, Lordship, why, and I'm saying that, my lord, obviously my learned senior friend would take that point.
And my lord, there are no pleadings as to why this court will have jurisdiction. That's an additional ground. No pleadings, no case made out as to why this court and not the DRT.
Unfortunately, Mr. Rai, this is a revisional court. You don't have.
Maybe. No, yes, you do. Yes, you do. It's a question of alternative remedy. Why is this not a correct forum, or DRT is not a forum in
There's looking
inconvenience?
for 5 minutes. Allow me to.
Yes, please. I'm just taking the point for my lord to consider.
How much time it will take, Mr. Chatterjee?
It will take a little bit of time. But I'll tell you also, the matter is not very long, but the facts are a little, my lord, big.
Your other matter is fixed at 3:45.
That's for my lord's judgment.
Yes. So it's your matter.
That's
After all, it's your matter.
definitely, my lord. But I will not take that much of time. I'll try and be as short as possible.
Yes.
My lord, initially, the 13-2 notices were issued. With a claim of, my lord, 18 crores. Rather, the claim was much more, 24, but there was a one-time settlement, but it comes to 18 crores. In that settlement, there are, my lord, 3, 4, 5 stages. Till the third stage, my lord.
5 stages means 5 installments.
5 installments, and with those installments, there was, my lord, an obligation on the bank to, my lord, release certain properties if those installments, my lord, were paid. In terms of that, in terms of the last, my lord, settlement which we have paid, my lord, is the third settlement. Till that point of time, my lord, we have paid to them 12.5 crores out of that 18 crores which was, my lord, being settled. The stipulation is that once the third settlement is paid,
But the submissions which you are making is from there.
you know, the learned government pleader is probably.
My lord, no, my lord, I'm on mute, my lord.
Yes, Mr. Chatterjee.
Once the, my lord, the second installment is paid, they were to, my lord, grant a license.
License
Or to stay, my lord, in my own property, which, my lord, they grant. which is a mortgage property, which they granted. License was granted in my favor. Then, my lord, what happened?
License to stay.
Yes, my lord. There was a conditional license to stay that was granted to me, my lord, in terms of that stipulation. I'll show that. Now, what happened is they were supposed to release that property. They did not release the property. We have gone to them. We have told them, look here, this is what it is. They said that we will not release the property. So we said that we can't go ahead with the settlement or whatever it is. They institute proceedings, my lord, before the arbitrator, praying for a relief, my lord, of possession, handing over possession of this property and several other reliefs. Yes, because, my lord, yes, they've gone to the arbitrator, my lord, because this is Aditya Birla Finance. There was an arbitration clause, my lord, in that earlier agreement. In the earlier agreement, arbitrator was appointed by the Delhi High Court. The proceedings, my lord, were on. Now what they did was, when this arbitration, all these proceedings, suits, everything is on, they file a section 14, my lord, behind my back. Section 14 with respect to what? With respect to that one-time settlement. And with respect to this property as well. Right. Relax. Now they file, my lord, a section 14, my lord, in terms of that.
You are aggrieved by an action under section 14.
Yes, I filed, my lord, section 17 before the DRT. Now I am saying, my lord, the DRT has lost its jurisdiction. Why? Because once, my lord, that settlement is my lord, on, and I have been granted a license, so I cannot be evicted without due process of law, my lord, with respect to that license. I am not claiming a right under, my lord, anything else. Once that license agreement, my lord, has been entered into and accepted by the bank, they cannot now invoke, my lord, section 14 behind my back and get an order. That's why I say, my lord, that DRT, my lord, doesn't have the jurisdiction today to even look into it. But the problem is, I went to the DRT. I again, my lord, adhered to whatever it is. I went there. DRT accepts my claim, but says I will not pass an interim order. I will pass that interim order whenever later or whatever. That's the impugned order, my lord, before your lordship. My respectful submission is that if you are invoking DRT, if you are invoking section 14, then section 14 itself should not have been entertained at all, because it is on the basis of the license agreement that I am in possession of that property and not on the basis of anything else. So that license agreement, my lord, is dehors the DRT jurisdiction. So section 14 could not have been invoked at all. So I'm saying there is inherent lack of.
Initially, you did not challenge an action under section 13(4).
We did so. There, below the one-time settlement was entered into.
Disposed of.
Disposed of.
That proceeding got.
That proceeding was kept pending for some reason. I don't know, my lord. It was kept pending. But the entire claim, my lord, was settled with respect to, my lord, that one-time settlement. I am saying, in terms of that one-time settlement, moment a license is granted, I am claiming a right under that license, not under, my lord, any of the earlier agreements which were part of the section 13(2), my lord, notice earlier. And you yourself,
One-time settlement
my lord,
arises out of that.
Absolutely, there is no dispute with respect to that one-time settlement.
So
In terms of
if you violate that one-time
I have not violated. I have not violated. In terms of that one-time settlement, my lord, they have granted me a license.
Yes.
And I have filed a suit for specific performance of contract with respect to that contract. That one-time settlement, my lord, is on the basis, basically, is a contract, my lord, between me and the bank. So it goes out of the realm of DRT. So section 14 could not have been invoked to get, my lord, possession of the same property, which is also the subject matter, my lord, of an arbitration instituted by them, my lord, before the Delhi High Court. So you can't choose forums the way you want. They can't be, I can't be vexed twice, my lord, for the same, my lord, cause of action, demeanor, whatever your lordship, my lord, wants
What
to
is
say.
the relief in the arbitration?
Same relief. Kindly have a look at the supplementary affidavit. I'll show you. Same relief. Supplementary affidavit to this is also okay. Well, the statement of claim starts at 37.
Have you served this supplementary affidavit upon them?
Tool আছে তো?
No, I don't think so. I have not received that. I have a 3-volume civil revision. I don't know whether my advocate record has received it, but I have not received it.
এটা তো রিভিশন
ব্রিফ মে আছে
এটা ভলিউম 2 আছে the volume 2.
The Chatterjee, you are snatching his brief.
No.
Sir is guiding.
I'm just pointing it, just helping him. Yes. The Ranjabati নিয়েছে. Aquila.
Also, I have to check supplementaries now.
It's the
statement of which they have
and Aquila Ranjabati, I know her, so I don't think there should be a problem.
Well, let him continue, well, not a problem.
Takes up the supplementary and it's their statement of claim, so it should not be a problem.
Yes.
Lord, it starts at 37. Kindly turns to page 61.
Yes.
Claim number 2. Mandatory injunction by restraining, prohibiting the respondents from selling, disposing, alienating, creating any third-party right title interest in the properties mortgaged with the claimant, and to compel or direct the handing over of the physical and vacant possession of the mortgaged properties, and restrain the respondents from withdrawing any amounts from any of the bank accounts held by the respondents. This is the claim, Lord, before the arbitrator. They are proceeding with this arbitration, good, bad, indifferent, whatever it is, Lord. They have filed this application before the arbitrator. Now, just to satisfy my lord's own conscience, Lord, may I take your lordship back?
Yes, Mr. Rai, if you have proceeded before the arbitrator for the self-same relief, can you also...
Malad, may I just put it as an example, Malad? Kindly does not take me amiss, Malad. Malad, I can proceed before the DRT as well as under the SARFAESI Act. This is transport. Transport, Malad, AI Act 2007, Supreme Court 712, says it's not a question of election. These are supplemental to each other. Now, Malad, DRT is for the purpose...
Relief, we will proceed before 2 forums.
Malad, I'm not
that you cannot proceed.
Malad, I am not proceeding. Malad, kindly appreciates. I am not proceeding. I have proceeded against those properties under the Act.
No, before the arbitrator.
The arbitrator is a different thing, Malad. I have asked for an injunction. But I have... Kindly, Mr. Chatterjee, just let me explain. Let me explain. Malad, I have an independent statutory right of enforcement of security interest under the SARFAESI Act. I am not required to go to any court. I have not invoked any forum, Malad. I have not done it. I have instituted under provision of statutory right. The invocation of this DRT is by my learned friend, not me, under SARFAESI Act. Now, Malad, kindly substitute, Malad. Sorry. Section 14, yes, Malad. Section 14 is in support.
It's under
It's not before the DRT, it's under the CMM court.
All right.
I have not gone to the same route. And Malad draws the analogy of transcourt. I have not gone to DRT, I have gone to the arbitrator for my relief.
All right.
Same thing. It is allowed in law.
With a lot of respect.
Malad, I only want to say this, Malad. I hope he can show that this point was agitated before the trial court below, though the matter is fixed on 25th, but let him show that also. Malad.
This is a question of law.
It is not a question of law at all. This is a question of jurisdiction and he has to take that point.
Section 17, I am saying, my lord, that the question of invoking section 14 doesn't arise at all.
No, 25th, Mr. Rai says something is.
No. They haven't even filed their affidavits in the meantime. So 25th, nothing's going to happen. 25th.
My lord, I can put in my affidavit by today. Let them have 7 days, my lord will fix the matter before the
Let
trial
there
court.
be an injunction of status quo. I don't have a problem.
Why injunction of status quo? That was refused.
I filed a writ petition before this court, my lord, asking the writ court to say, send the police to my house. I can't wait for a day.
Well, let him take the point, my lord, whatever he's pointing out.
I don't have a problem. Let him say he wouldn't do anything.
No. Why should I? I'm saying this court as an alternate remedy shouldn't invoke the jurisdiction. I'm also taking that point.
Yes, Mr.
You put in that money.
Now kindly turns back, my lord. Kindly takes up the revision application once and sees, my lord, that one-time settlement
page.
Yes.
You have to say the volume, then the page.
First takes up, my lord, page 88. পেজটা আরম্ভ হচ্ছে কোথা থেকে? এটা উর্মিলার কাছে ছিল। Milord, it starts off, Milord, from page 86.
Yes.
Kindly, Milord, turns over to page 88.
My lord, only one imputance, my lord, kindly does not take the MS, my lord.
Yes.
The interim application which they had made before the trial court, my lord, is not a part of the CO. So, my lord, let him complete today. Let me come back with that tomorrow and I'll make the submissions on the basis of the interim application.
All right.
My lord, whenever your lordships call me, I'm there. So I'm just beseeching your lordship that. So
Yes.
let him finish today. I'll come back tomorrow.
Note, Mr. Rai.
Grateful.
Then takes up page 88.
Yes.
Turns over, Milord, to 89 and then the consent terms start. 89. These consent terms are being entered into between the first party and the second party.
Page 89.
89, Milord.
Yes. Which one? Yes.
A1. It will take a little bit of, Milord. I'll show you a lot.
Yes.
Into between the first party and the second party to record the
Who is
understand.
the first party?
First party, Milord, is the bank, and the
First
second
party
party
is the bank.
is myself.
Yes.
My lord will see 86 on that.
Yes, yes.
Which have arisen between them on account of the default towards non-payment of the liabilities by the second party and consequently for closure of loan facilities. That an amount of 24 crores, no lakhs, right? No, crores. Due as on 18th of
Mr.
October.
Chatterjee, you should not
2022.
find it difficult to pronounce.
Very difficult for me. Milord, I can't even see the number of digits which is involved. I even with my, Milord, fourth eye, Milord, I can't see.
Will not be difficult for you to
It is
read lakhs and crores.
incomprehensible. I just hear them, Milord. It's all in the air, but can't see them.
Yes, yes.
Due as on 18th of October 22 is outstanding and payable by the second party towards the loan availed by them from the first party. Hear it. And then it's given. 3 is important. Now, in terms of the settlement arrived between the parties.
18 lakhs. Within 31st of September in 5 installments.
Gives you, yes, brother. Just gives me 1 minute.
Yes.
In discharge of its liabilities towards the outstanding loan facilities availed by them, the second party agree and undertake to pay the first party an amount of 18 crores towards settlement and closure of the outstanding liabilities. First party in full by final the 30th of September 2023 in 5 installments. Lordship got that?
So end date is 30th of September.
My lord. Now this was extended. That will come later.
So in the following manner, that is
important. The following manner is important. That
Yes.
is where, my lord, the
Which
entire problem starts.
Which
See the
clause?
first one,
Yes.
A, 5 crores paid. No problem.
5 crores. So A has been
Complied with. Turns over to B. Second
Yes.
installment of 7 crores. Below, this was rewritten by a contract at page 107. To this 7 crores became 6 crores 25 lakhs.
So all right. So the modified terms complied with.
Complied with. I'll tell you, Lordship. I'll show you, Lordship.
Yes,
In the
next.
first party, now comes the important part. The second party is willing to pay the said amount from selling of one of the secured properties, that is the immovable property, that is plot of land measuring such and such, together with a three-storied building.
No,
such
so
and such.
this pay the said amounts means this 7 crores.
Yes, my lord.
For this you have to sell.
Sell, done.
But that is a modified amount.
This was done.
Yes.
This was done. Then it is agreed between the parties that the sale of the immovable property mentioned herein shall be according to tripartite agreement, all complied with. Turns to C. Third installment.
Yes.
1 crore 25 lakhs to be paid by 30th September 2023.
So this is the last.
No, this was complied with. But there were extensions thereafter.
All right.
There's
Yes.
no dispute
This
on
was
that.
also complied with.
Complied with.
Next.
Then comes to কোথায় গেল? Huh? এক second. Then Millard comes to D. D was also complied with.
Yes.
License
Yes.
কোথায় গেল? 92. Kindly turns over to 92. 92. I'm sorry.
Yes.
92, Millard. If your lordship sees 5.
5 or E? Oh, 5.
5.
Yes.
Forget that was not done, Millard. 5 is the one which is there. That on the receipt of the monies as stipulated in clause 3 above. Kindly turns back to clause 3 once. That is the third installment, 1 crore 25.
Yes.
That your lordship finds at page 90.
Yes.
It shall release the mortgage properties in the following
Fee-
manner.
Clause fee is the entirety, not only this 120.
No, I'll show you, lordship. I'll show you, lordship. That was what was there, which was my liability. Their liabilities, after each installment is being paid, they were supposed to periodically give up the mortgage properties to me.
Yes.
This is their
To
stipulation.
enable you to sell.
Not just sell, also to even this
To release.
property is to release as well. See 5 onwards, that's their liabilities. It starts from there. That on the receipt of the monies as stipulated in clause 3 above, the first party agrees that it shall release the mortgage properties in the following manner. On receipt of the 5 crores, no mortgage property shall be released. Then, on receipt of the second installment, 7 crores, by the first party as stated above, the property specified in 3B1 above shall be released and possession handed over to the proposed purchaser with the consent of the second party. Palm Avenue sold, money taken by them, no problem at all.
This was sold.
Yes, no problem at all. Then, simultaneously, the first party shall grant permission, mere license to Mr. Aniruddha Banerjee to reside at one of the mortgage properties, that is such and such, on the entire 4th floor of the said building, having an aggregate super built up area of 3,820 square feet, along with 2 servant rooms, such and such, on the ground floor and 3 covered car parking spaces on the ground floor of the said building, constructed on the land comprised in the said property being 6C Kiatola Road. It is expressly agreed between the parties that Aniruddha Banerjee shall not claim any equity or create any third-party rights over the said property, and it is merely a right to stay with no additional right. It is further agreed that the title deed in relation to this property, below its Banerjee, to this property mortgaged to the first party shall be.
Whether I should take up this matter or not.
That's why I pointed out its Banerjee.
Yes.
Mortgage to the first party shall remain in the custody of the first party till such time till the balance amounts contemplated in clause 3 above remain unpaid. On receipt of the third installment of rupees 1.25 crores, on or before Atto, the property specified above shall be released and possession handed over to the proposed. Now this,
Give me a minute.
this,
Give me a minute. This third floor flat,
my lord,
under point C,
My lord.
5C.
yes, my lord, is the
This is-
Kiatola property.
This is the Keatola property.
Yes, my lord.
So
The subject matter of the section 14, my lord, is the Kiatola property.
Keatola property.
My lord.
So it will be released after this 1.25 has
Yes,
been
Milord.
paid.
Yes, this they did not do. Did not do.
And according to you, you have complied with 1.25.
Yes, Milord. License was created,
Yes.
but the release did not happen. Milord, there is another property which your lordship will see. এটা হলো সিতে কোথায়? এটা Milord, this page 90, if your lordship sees at 1.25, page 90, my lord sees C1, yes. C1, this is Milord the Southern Avenue property.
Yes.
So this was to be released.
C1.
Yes, Milord.
C1.
Clause 3C1 at 93 compares that with
3C1, sorry. I was looking at 3B1.
3C1.
3C1
shall be released and handed over to the proposed purchaser with the consent of the second party along with the title deeds of the respective properties. When do they do that? They do that, Milord, on receipt of the third installment of 1.25 crores on or before 30th September 23.
Yes.
And this was extended, Milord, till 30th of April 24. This they did not do. Once
according to you, that this property was not released.
No. Which was
So you have complied with by paying 1.25 within the time limit as per the agreement.
Moment they did this, I file a suit, Milord, for specific performance of this agreement. Now, why I am saying, Milord, that section 14 would not lie is once that this license is being created, have a look at the license, Milord, which is এখানে এটাতেই তো আছে না? Kindly have a look at
where is your tooth?
Alipur.
No, sorry. The plaintiff of the suit, where it means, have you annexed that? I'm not asking you where have you instituted.
No,
Where is the plaintiff of this suit?
Plaint, Milord, hasn't been, I'll find it out for your lordship.
All right, yes.
Kindly once turn to 121 once, I will take your lordship to that. I'll take your lordship to that.
121, what
Yes.
is that?
I'm sorry, not 121. 112.
Yes. This is the conditional license, which they have executed pursuant to that.
Exactly. So my rights
This is not in dispute.
Not in dispute. And once this is there, Milord, I am not exercising my rights vis-a-vis, Milord, the DRT Act. Neither are they. They have now become a licensor. I, though being an owner of the property, has become a licensee. They, being, Milord, a secured creditor, have become a licensor. So the relationship now, Milord, is no longer that of, Milord, of a mortgagor and a mortgagee, or a secured creditor or a secured creditor. It's not that.
Mr. Chatterjee, is the mortgage extinguished by execution of that license agreement?
No, but
so that relationship remains.
Might remain, but my right vis-a-vis this, my license,
but this arises out of that.
It might, Milord, একটু দাঁড়া না বাবু, একটু রিল্যাক্স কর, আমি বলবো, তুই বস যখন বলবো না বলবি, রিল্যাক্স কর. My right vis-a-vis, Milord, my license, yes, it has emanated from a mortgaged, Milord, document. I understand that, but it's a right nonetheless, which is independent, Milord, of whatever is there, Milord, in the mortgaged document, and they are inducting me in terms of this license. Kindly appreciates that. So today, if they have to throw me out, they can't go back to the section 14 proceedings and say that, look here, give me everything behind my back. So this is a misnomer. You have chosen to give me license. You would not have chosen to give me license. You might not have done whatever, but you chose to give me license. Why? Because I was paying you money. Milord, 12.5 crores, Milord, they have digested. It's not that they haven't taken money from you. I have defaulted in payment of any installment.
So, Mr. Chatterjee, according to you, there is no amount due as per this one time.
5.5 crores is due. and I want to give it to them, but they have not accepted it.
Why?
I don't know. Now what they've done, my lord, by going to the arbitrator, they want another 18 crores, my lord, from me.
Why?
Well, that's for them to, my lord, answer that.
No, no. You
They are giving us,
because you have challenged. You
my lord,
must be
there is
knowing
no
that-
dispute. There is no dispute, my lord, that 24 crores was due.
So why they are claiming this is
Interest. They're all interest. All interest.
Say so.
All
So this
interest.
is with regard to the interest or late payment.
Can never be, my lord, in 2 years there will be an interest of 18 crores.
That
cannot happen. Can never happen. Can never happen. And I have filed, my lord, a specific performance suit on this, where there is, my lord, which is pending, my lord, before the Alipur court. The plaint is at 142.
Yes.
So now the situation before your lordship is whether section 14 could have been invoked or not. I am on my lord before your lordship is the invocation of section 14 is wrong. Section 14 is invoked. Securitization Act of where the possession of any secured assets is required to be taken by the secured creditor, or if any
So
of
according to you, that property loses its characteristics of a secured asset, and
you can't take possession from me because of
cannot now be said to be a secured creditor.
Sir, what
according to you.
happens here is yes, Lord, no, I am not taking my case that high. I am trying to, Lord, make out a case is that invocation of section 14 is a draconian law. Section 14 is where I have defaulted payment of money, no section 17 pending, because in the tabular statement they will have to say if there is a section 17 pending or there is a stay or not, because everything happens, Lord, behind my back.
That 9 point
exactly
affidavit,
9-point affidavit, where 99% of the time, the creditors don't say the truth. Here, Malad, creditors don't say the truth. Though I firmly believe, Milord, section 14 could not be, Milord, disposed of without service of notice, but the law is else otherwise. Milord, your lordship remembers Justice Pratap Rai's judgment when police help first came in. This was a submission of Justice Jyotirmoy Bhattacharya that I was the judiciary, where
rule number 33,
where he was told the principle of natural justice has to be adhered to. So law changed, Milord, with respect to Order 21 Rule 97. But here is a situation where section 14 should definitely be, Milord, there should be a notice served on the other side. Is no longer res integra. No longer res integra. I am not even going to cannot reopen the issue. Here is a situation where, Milord, where section 14, I say, Milord, is the court sees it. The court sees that there is a license granted. Today, Milord, if a license is granted, and if it's revoked, straight away, Milord, going to, Milord, asking an authority in some other act, asking me to dispossess, cannot happen. Once the license is granted, Milord, the entire set of acts change. It doesn't remain solely, Milord, in the domain of, Milord, the DRT. No. My respectful submission, Lordship kindly tests it. I have entered into a separate agreement, dehorse whatever, in their presence. They are a party to that agreement where they have inducted me as a licensee. And it's not that I have, Milord, not paid them in terms of that.
I was only thinking of this. The points which you are raising. Now, this is ultimately the issue to be decided by the DRT.
That's why I say, if I say, Milord, that I have a prima facie case to go to trial, I'm entitled to an injunction. This needs to be thrashed out. And if I have a prima facie case to go to, Milord, trial, injunction is there for the asking. The learned judge says, you have defaulted, I will not pay. I have not defaulted. I have paid you 12.5 crores and I'm willing to pay you.
Oh, there was a subsequent default also.
No, because he did not release the money, my lord. After receiving the money, he did not release the property. And that's why the specific performance suit.
Show me once that clause of release.
Yes.
For releasing.
Yes.
That their obligation to release.
Certainly, certainly. That starts from clause 5, page 92.
Page 92 or 93?
93. And
Yes.
your lordship, my lord, what is relevant is 93D.
Yes, 93D.
On receipt of the third installment, on or before 30th September 23 as stated above, the property specified in clause 3C1 shall be released and possession handed over to the proposed purchaser for the with the consent of the second party along with the title deeds of the respective property. Not done.
So this is, according to you,
Default on their part.
yes, according to you, after compliance of this 1.25,
My lord.
so everything with regard to 3C1 ends.
My lord, I would not respectfully submit, I can't say that. I am saying, my lord, that they can't take advantage of their own wrong.
No, yes, no.
I am not saying, my lord, that this has come to an end. This is a
No, with
default.
regard to 3C1.
Yes, yes, just with respect to 3C1.
Yes, yes, I'm saying that. With
I am
regard
not
to,
saying that the entire thing has
no,
gone.
no, no, no. According to you, upon payment of this 1.25, not
there
only
was an
1.25,
obligation.
the other payments till 1.25.
Exactly. Till that amount was being paid to them,
Yes.
there was an
So-
obligation on their part.
Yes, so 3C1 has to be released.
Has to be
So they cannot hold on to
Hold on to it.
3C1 after compliance of 1.25.
My lord. And the license still remains. The license was never revoked. Though, my lord,
Mr.
there-
Chatterjee, if they're obliged to release this, there's no question of license
not the
because
same property. This is not the same property. There's
Why?
a separate property. License is with Milord with respect to the Kiatala property. And releasing Milord is with respect to Milord the Southern Avenue property.
sorry, I was mistaken.
That's why I understood your lordship's mindset.
Yes,
Milord.
yes.
That's why
3C1.
3C1 is with respect to Southern Avenue. Midnath Sharoni. Page 90,
So
bottom.
what were the properties which were mortgaged?
There were quite a few of them. There were 4 properties, one Milord at Southern Avenue, one at Palm Avenue, one at Kiatola.
No,
and
where
one
is
at
where are those mentioned? All the properties?
Dhapa.
Mr. Chatterjee, where are all the properties mentioned in this agreement?
Yes.
Where?
Kindly turns back to, I'll show you a lot. Yes, Milord, in page 90 itself, your lordship will find.
90, is it clause B1?
B1 is with respect to Palm Avenue.
No, is there anything anywhere mentioned of all the properties?
It should have been there, Milord, in that arbitration
No,
agreement.
not here, not in this agreement.
And even this agreement also. In this agreement also. Also, it was mentioned, Milord, 3 in the initial agreement.
One is 5A Palm Avenue.
That's the Palm Avenue property.
Yes, one is 5A Palm Avenue.
Yes.
What is the other property?
This is, Milord, the
One is Megnath Shah.
that is the Southern Avenue property.
It's a Southern Avenue
So
property.
3C1, Milord, is with respect to Southern Avenue property.
So they will release
The
Southern Avenue property.
Yes.
So according to you, that has not been done.
Not been done.
And you are inducted as a licensee in respect of Kiatola property,
Kiatola.
which is also one of the mortgage property.
One of the mortgage properties. That's my residential house.
Yes. Yes.
And there is another property, my lord, which your lordship will find at 91.
91.
1. That's D1. That's the Dhapa property.
That's D1.
D1.
That's the landed property.
The landed.
Yes. Yes.
So, Milord, this is basically, Milord, what my situation is. So I have 4 properties, Milord. 4 of them were mortgaged with them. In one of those properties, Milord, I am a licensee. Now, Milord, a license was granted, there is no dispute. Once the license is granted, and I'm claiming a right under that license, my lord, section 14 could not have been invoked.
14 is with regard to which
This
property?
Keatola property, the licensed property.
Only with regard to that.
Yes. And that's where I'm saying a fraud is being played on court.
Yes.
Blood, the earlier section 14 was filed, that was blood rejected.
Section 14 allowed on
The conditional license. There was a section 14 first. That section 14 was also allowed. Kindly turns to the conditional license.
Property.
This property. This property. Have a look at
14 was allowed.
Yes, yes.
What happened after that?
License 112.
Oh, after taking possession,
They
were
have
inducted to as a
exactly,
license.
Exactly. Kindly have a look at 112. Turns to 112.
So your submission will be a second 14 does not lie.
Just not that. They will say, my lord, that there is a separate cause of action. They can say that. Why I'm saying this is, you have taken possession, granted me a license. So that whatever vis-a-vis the Keatola property, I have an independent right of remaining in possession in terms of the license granted by you. So section 14 could not have been invoked. Lord, I am on a very small premise. I am not extending, my lord, my premise any further. I am saying you have invoked a provision of law. You have taken possession in terms of that provision of law, and you have then given me license as per your own free will. Moment you have given me that license, my rights are extended beyond the Mortgage or the Securitization Act, and a separate right under the Easement Act comes in. And if I am a licensee,
which section you are trying to invoke?
I am not invoking anything. I am saying grant of a license. Moment there is a grant of a license, I have a right to remain in possession without
Cannot be evicted without due process
of law. Now, what is the due process of law is not a section 14 application, because
Eviction
this
to the civil code.
Yes. Now they have invoked, my lord, the civil code by way of an arbitration clause, which I will take a point, my lord, before the arbitrator, that this license was never had an arbitration, my lord, clause there. That's a separate aspect altogether. I am not even getting into that before your lordship. But they have prayed for possession, my lord, before the arbitrator again. So I am being vexed, my lord, in two forums at the same time. That cannot happen. They have to choose. They can't say, Transco did not say that you can evict a person through the DRT and also through the arbitrator. Transco didn't say that. Transco said, my lord, with respect to whether you want to go to the DRT, either by the DRT Act or by the Securitization Act. That is what they could have done. This is a completely different thing. So my rights vis-a-vis, my lord, the property is now I am invoking my right, my lord, on the basis of the license granted to me. So that right is being taken away, my lord, by my lord, may I ask this question to myself? Can section 14 be invoked to, my lord, evict a tenant in the property? No. Section 17(4)(b), my lord, only says that the DRT can see whether I'm a pre-mortgage tenant or a post-mortgage tenant, nothing beyond that.
That is between the borrower and the third party, Mr. Chatterjee.
I bow down, but here I have become a third party by legal fiction.
An arrangement between the mortgage.
I have absolutely. So by way of a legal fiction, my lord, I have now become, my lord, a licensee in my own property.
It's not an elevated status, Mr.
Not at all, not at all. But my right to remain in possession comes in. I am not for a second saying that it's an elevated, my lord, right. But it's a right.
Is that right?
That right to remain in possession as a license is a strong enough right. Cannot be evicted, my lord, without due process of law. And I don't need to show your lordship judgments on it. If I'm a licensee, there are judgments right from Olga tells you can't say that even a trespasser can't be evicted without due process of law. But that was watered down a bit later. But the law remains the same. If I can show a semblance of a right, I cannot be thrown out without due process of law. So that
Is
semblance
the rider without due process of law.
Exactly.
Now, what is the process of law
Exactly.
that is to be
That's what I am
judicially
on.
tested?
That's what I am on. Now I am saying, my lord, that you have section 14. Once you invoke section 14, I can't go anywhere else apart from section 17. So I have gone to section 17, where my point is that section 14 could never have been invoked. The judge looks into everything, but says, I will pass an order sometime later. Now, armed with this order, they file a writ petition, my lord, before this honorable court, saying that for police inaction, please grant me police so that I can take possession right now. Section 17 pending, section 14 arbitration pending, where they have paid for recovery of possession. Section 14 invoked, section 17 is pending.
Police inaction at whose instance?
Their instance.
Can it be done?
Cannot be done. I'm on that. But that writ petition is on the basis of is like an execution application. So what executing what? That section 14 order?
We in a division bench have decided a similar issue with regard to this.
Malin.
At what stage or who can approach for police help to take possession under section 14?
Even earlier, my lord, if your lordship sees when every avenue is closed. My lord, your lordship, remember that I wasn't aware of my.
Not the secured creditor can approach.
My lord, in our civil court, if your lordship remembers, I'll come to section 14. In a civil court, if your lordship remembers, police help, everything was done, all avenues taken care of, but even then the landlord did not get possession. Then the constitutional court was said that because it's a constitutional court, it can go beyond order 21 rule 97 and secure that when every avenue is closed, it's only then that. But my lord is
justice.
Yes, but my lord has said that the secured creditor cannot go.
See the
Under section 14.
Section 14.
Yes. But that's one aspect completely. I bow down. The problem is, my lord, here with me, why I need an interim order is because section 14 order is already passed.
Yes.
This order, my lord, is under challenge, good, bad, indifferent. If it's under challenge somewhere, and I'm saying section 14 could not have been invoked at all. At all. If that is the situation, then, my lord, then I'm entitled to at least an interim order for protection till my section 17 is heard out.
How much time more you will?
Another 10 minutes, 10, 15 minutes. I'll just show you, your lordship, the 3:35 বেজে গেছে? আচ্ছা। But 10, 15 minutes. I understand.
Because
I understand.
Because I have to
Gives
rise
me-
a bit early. There is a
No.
also that is.
No problem at all. My lord, your lordship, will keeps it tomorrow, day after, whenever your lordship pleases. I'll take about 15 to 20 minutes more.
3:30 tomorrow.
2 o'clock? কালকে থাকবি না? I need her. It's a day after tomorrow. Tomorrow.
Tomorrow, day after.
Well, I am only thinking because day after it is.
Chatterjee which is to be heard. It's an urgent matter which is to be heard. For the litigants, it can be done.
I just kept it tomorrow, Malat.
Tomorrow,
Tomorrow, Malat.
3:30,
Time.
taken up at 3:30, not 3:30 resolution.
Malat, 3:30, Malat. Grateful.
Yes.
We're
Very
very
good.
sure that there will be a 3:30 tomorrow. Just look at his face, I'm sure he knows.
Well, Malat, I'll have to do their tag, Malat, then.
Mr. Rai will appear even if it is 3:30.
Malat, I will have to do their tag according to my learned friend. Malat.
Yes. So, Mr. Chatterjee, kindly ensure if the supplementary who you may have served
I'll give
for
another
abundant
copy.
question, please give an
Certainly.
extra copy to them. Otherwise,
Grateful, Malat. Grateful.
fixed
Certainly.
matter to them.
At 12.
If your Lordship Miller grants me this indulgence, that may it appear on the within the first 5 matters, otherwise I lose everything. There was an order. I want to accept
Calcutta. About with the High Court of Calcutta.
My-
Why? What is the grave urgency, Mr. Bhatt?
The grave urgency is there was a direction to pay the occupational charge directly to the parties. Now,
Not paid.
no. We want to pay, but there was no, because of the fact that to whom it has to be paid, that was not specified. Therefore, we could not
You
pay.
do not know, Mr. Bhattacharya, to whom it has to
No,
be paid.
Miller, it has to be deposited, but kindly,
Person whose property you are occupying.
no, Miller, kindly consider.
Pay to him.
I want to comply within 2 days. I want extension of time for 2 days or 5 or 7
Any
days.
caveat is there? How can it be extended, Mr. Bhattacharya, without?
Miller, it has been.
Who is for the caveator?
নামটা জানিস?
What will happen if it is taken up serially tomorrow, Mr. Bhattacharya?
Miller, I do not mind, but kindly give this little indulgence so that it comes, Miller, within the first 5 matters. Kindly give this indulgence.
My lord told me to remind my lord at the time of rising.
Yes.
My lord, we are suffering an interim, though there is no interim order recorded, but my lord requested us not to take any coercive action with the bank, my lord. 102, my lord.
102.
My lord.
102
I have also informed the other side.
102 are.
And 42.
আজকে লিস্টে